My lord,
Yes.
I beg to mention at number 21, my lord. Can this matter be released after 2 weeks, my lord?
21.
Yes, my lord.
Why?
See, today just filing with somewhere my file was somewhere this long, where somewhere I could not trace out. That's why difficult. That's why I find getting a bit difficult.
This is of what?
This is my related to land dispute only.
Huh?
It's relating to the land matter, my lord.
Hmm.
The allotment was land allotment was granted to the appellant, my lord, and thereafter subsequently it was cancelled, my lord. Against that cancellation, the writ
There is
petition
a
was filed,
overlapping.
my lord.
Overlapping.
Over it is yes, this was the case, but it is in fact it was not a overlapping, my lord. There was a after
No,
before
land has been allotted to the BRTF.
Yes.
BRT, it was, but initially it was earmark survey was done, my lord. Everything was done, my lord. Thereafter, the whatever surplus area available, it was after making survey and ground measurement allotment was done, my lord. And subsequently, that's why, my lord.
I don't think so.
Madam, that is the content of the appellant, madam. But our
And
content
only,
is different.
my lord, my only, my prayer, my lord, was to at least let there be a complete ground survey that at least to that aspect, my lord. That was, but not considered by the latest single bench, my lord. That's why, my lord. My lord, after 2 weeks, my lord.
All right.
Only prayer of Mr. T. Tagum, learned counsel for the petitioner, let this matter be listed after 2 weeks. Come on. Please, the Mr. Aristinabam, learned additional advocacy for the state respondent is present.
Deeply obliged.
Millet, I'm mentioning at number 1 on behalf of Planet Senior Counsel, Mr. Tara Lordship.
What is this? There's nothing. 1
Lordship,
and 2.
yes, Your Lordship. He remains in this person, Lordship.
Against you. Yes, what happened?
Your Honor, I'm for respondent.
What is the status?
As per service is completed.
No. On the merit. Yes, Mr. Tagum.
My lord,
The legislature has directed to
give promotion to the person who is eligible, my lord.
as per the rules,
Yes, as per rules. Now,
as that of the appellate.
yes, my lord.
So
My lord, only as per my lord, if they're eligible, then that they will consider.
now we wanted to know what is the status now. The appellant have been they reverted back.
Yes, my lord. They have been reverted back, my lord. And after filing, my lord, the subsequently against reversion, my lord, they have filed the writ petition, my lord. There's a interim order in their favor, my lord. Now this entire the writ petition pending before the land single bench, my lord, that will depend upon the decision on this, my lord, the writ appeal, my lord. This is based on the same issue only, because rule says, my lord,
See, London single judge did not say any adverse against the appellant.
my lord. But
You have just it's your own it's not direction by this court.
my lord,
It's your own on your own you have reverted them
My
back.
lord.
So they are working.
they're working.
They're still working as
Working, my lord.
TGT.
Yes, my lord.
They just stay.
My lord. Yes.
Yes, then what's there? There's nothing against you.
Lordship,
There's nothing against you in the judgment. Impugn judgment.
Lordship, 2 weeks.
What is Mr. Tara?
Lordship, due to medical emergency, Lordship, his father has been taken ill. That's why he couldn't make it today.
There's nothing actually.
That's the rule is there, but as per rules only. my lord.
Only you have to consider the promotion as per the rules only.
Yes, my lord.
Whoever may be,
Yes, my lord.
writ petitioners or appellant.
Only the contention made by the appellant and writ petitioner is that they are taking the aid of the provision for direct recruitment. Direct recruitment is educational qualification as well as the other the eligibility criteria there for direct recruitment. But for promotion, my lord, it's a specific provision there, educational qualification. That is 5 years.
That will be strange. For promotion, you have a different
Yes,
qualification.
yes, my lord. That is only.
How can you have that?
My lord, that is why promotional we have a different
See,
criteria.
it has to be below 50-50.
My lord,
50% by direct recruitment and 50% by promotion.
my lord.
Right?
They are
For promotion, you have a lesser education qualification.
my lord.
How can this be?
My lord, because
Same post.
same post, but education qualification, because they have this is for the primary teacher who is serving, my lord, by virtue of the experience, my
See,
lord.
to
That's
be
why.
promoted, they should either, whether it is a direct recruitment or promoted, you will have to have a same qualification for the same post.
My lord, for education promotional, my lord, that's why, my lord. They have not put to challenge that rule also, my lord.
No, otherwise also, how can you promote like that?
My lord, that is why, my lord, the department has followed the what is there in rules only. Rule says for promotion, my lord, the 5 years regular service as a primary teacher.
That's all.
My lord.
No,
And other qualifications also there. It is already the appointment of recruitment of the primary teacher is rule. It is governed by the other set of recruitment rule, and this is for a promotional matter.
I told you, let's dispose of the matter.
Mhm.
I think anyway. Think about it.
My lord.
Mr.
P. Roja, Your Lordship, on behalf.
P. Roja, on the prayer of Mr. P. Roja, learned counsel appearing on behalf of Mr. Titi Darala, senior counsel for the appellant. Who is for item 2?
Your Lordship.
You are in item 2.
Yes.
Appellant.
Respondent.
Your response. Yes.
On the ground that Mr. Tara has some medical problem. Therefore, phrase for listing of the matter after 3 weeks.
2 weeks, Your Lordship.
2 weeks. Mr. In view of the above, prayer for adjournment is accepted. Next prayer, Mr. So-and-so are present, huh? Tita Gumpur, Land Standing Council for Education Department, and Mr.
L. Byung, Your Lordship.
L. Byung,
Byung.
Land Council for Private Respondent are present, huh? Accordingly, list this matter after 2 weeks. Yes.
Your Lordship.
Obliged.
Your Lordship, another matter, Your Lordship, item number 6.
Yes, same order.
Item number?
6. 6.
This for respondent, huh? This is regarding that DLRS.
Yes, my lord.
Okay.
Obliged.
The ground of medical problem, huh?
Your Honor, I beg to mention item number 18. The leading counsel is out of station for some urgency. I have informed the other party also. A matter may be fixed after 3 August, 3rd August.
Why?
Some leading counsel is out of station for some urgency.
What can we do if he's out of station? Anyway, on the prayer, Mr.
Item Tinguki
T. Nguki,
on behalf of ESMO.
Learned Counsel appear on behalf of Mr. Esmo, Learned Counsel for the petitioners. Let this matter be listed after 3 weeks. 3 weeks.
3
My
weeks.
lord, my presence may be recorded. I am for the respondent number 3.
MS J. Doji, Learned Counsel for the the respondent number
3.
3 is present.
Much obliged.
May I please, sir? My lord, I beg to mention item number 17.
17.
Yes, 17.
Yes.
Leading counsel of out of station. I on behalf of C. Modi, amicus curiae.
On the ground that Mr. C. Modi, London amicus curiae, has some personal difficulty. Mr. So-and-so, Learned Counsel appearing on his behalf, pressed for and is granted. Press for adjournment of the matter. There is a lot list matter after 3 weeks.
Published.
Item number 3.
Yeah, you are supposed to file the affidavit.
Yes, Lordship, in this matter, Topijin is appearing and
Where is-
she is studying in traffic, Lordship.
Hmm. After some time, we'll dispose it of. Dismiss PIL.
Item number 4.
Notice has been issued.
Yes.
So what is to be, the record should be called or what?
This ballot, the call for the records also, and they're supposed to respond.
It's an appeal only.
Yes.
Any affidavit, you would like to file affidavit or objection? anything?
We haven't received instruction yet, Lordship.
And Mr. Deepang, Land Counsel, Land Senior Counsel, assisted by so and so. Sitaja, Land Counsel for the appellant.
We otherwise don't have proceeding.
Hmm?
You know,
You can take it up. Please. We've taken it up already. Right? On 19, we have taken it up on being listed. Call for the records. List the matter after 4 weeks. 4 weeks. The respondents may file affidavit if so advised in the meantime.
Item number 5.
Will admit, call for the records. Huh? No, that's already admitted. Yes. Next time we'll see. Yes.
May I please, my lord? My lord, this is appeal, my lord, against
That sentence, huh? Suspension of dismissal. Not happy? We'll consider. We'll issue notice. We'll consider. Don't worry.
But my lord, in my humble submission, my lord, it will take some time, my lord, to hear the main case, the merits of the case, my lord. So I was just,
So that's why we have issued in the IA also. We have issued notice.
My
We'll
lord.
consider on next day.
my lord.
7 and 8.
Yes, you are supposed to obtain instruction.
My lord, I'm yet to receive any instruction, my lord. We have,
This is third time or fourth time.
yes, my lord.
What's wrong with the NSDCL?
My lord, from the Itanagar, my lord, we have already informed the headquarters, my lord, but then we have yet to receive any instruction, my lord. May I humbly pray, my lord, if my lord, this please to allow some more time, my lord.
Next week.
My lord, my lord.
No, this can be disposed of if it is done. Have you seen this order?
In fact, my lord,
After entrusting the consultant, whether realignment has been done or not. If it is done, matter ends there.
my lord, we have given a notice to the consultant, my lord. The re-element was there, my lord. They have given the DPR, my lord. But then the cost, there is a cost escalation, my lord. So we are not happy with the cost escalation, my lord. So we have given it for reconsideration, my lord. So that has to be considered, my lord. Therefore, my lord.
Okay, I had Mr. K. Land Counsel for the petitioner.
Mahabulu consultant.
Next para. Mr. Opada, London Counsel for applicant, public applicant NIDCL. Press for further 2 weeks times to obtain instruction.
Mulnagol consultant.
Mr. Pledge allows according to this matter after 2 weeks.
May I humbly pray, my lord, can it be 3 weeks?
And Ratan Learned Additional Advocate General for the state, as well as Mr. M.S. Y. Gao Learned Counsel appearing on behalf of Mr. M. Kato Learned DAJ are present.
3 weeks, my
Make
lord.
it 3 weeks then.
Deeply obliged, my lord.
Deeply obliged, lords.
Item number 9.
Affidavit. Have you filed the affidavit?
My affidavit is ready, is sent for law betting.
Who is
Within a week we will file.
for the petitioner?
Petitioner is not there.
These are
Petitioner,
necessary thing.
Ibomili.
These bills are unnecessary.
Yes, I think last time also they remain absent.
Anyway, you filed the affidavit.
Yes.
Not appears for the petitioner on court. As prayed for by Mr. G. Tarak, Learned Standing Counsel, RWD. Further,
Respondent number 1 only.
for respond number 1. You are also filing. And Mr. Elper Learned. You are for?
5, 6, and 7.
5 respondent. Respondent 5 and 6 and 7, as well as MSP Pangu Learned State Council. Further, 6 weeks time is granted to file affidavit in.
We have filed a lawsuit for respondent number 4.
Then you write G. Tarak and Elper.
Item number 10.
Not make it 4 weeks, not 6 weeks. Same thing. Same PMJ.
This case, my lord, since all the works which they are claiming compensation all complete in the year 2010.
There's a bare guidelines to, I mean, considered by the panchayat and all.
Yes.
Whether the certain not exactly compensation can be given. That's all.
Normally the villagers, they are the one who donate the lands.
Who is this? Who is the petitioner here?
I'm the petitioner on behalf of Titapak.
Who is the petitioner? Not the villager.
Petitioner
Not the
is
villager.
okay, the Kai Siva.
Who is?
He is in
He's
practicing
of,
advocate.
he's of that village.
No.
He's a practicing advocate.
Yes.
These are unnecessary PLs. You have filed the affidavit?
Yes, I have filed.
Yes, we'll hear you.
Lordship, 3 and 4 has already filed. Rest of the
3 and 4.
3 and,
RWD.
Yes, RW 3 and 4.
and rest of the respondent is
It's
not
all right. RWD is enough. It's a PMJ executed by the RWD. Secretary is there. Secretary is a party here. RWD secretary.
Let's check. Chief engineer. Yes,
Yes.
4.
Argo, we'll hear. These are unnecessary.
Lordship, kindly this matter will be fixed on another day.
No. Today.
Because my senior is out of station, Titapak. Titapak is hearing matter. This matter may be hearing.
Yes, what about the union? Where is the learned Deputy Solicitor General of India? And state? What is your stand?
Some more time, your lordship. The department is seeking some more time, Your Lordship. in this
My Lord, may I submit, my Lord, Your Lordship is aware. This PMGSY, my Lord, there is no any concept for land compensation, my Lord. The query which I have fallen to Your Lordship regarding, my Lord, little bit, my Lord, some sort of compensation to the village authorities, my Lord. Perhaps, my Lord, the user agency, my Lord, they must be allocating some small work, site drainage, all these things, my Lord. But that we don't know. But here is the question, my Lord, they are, what exactly they are asking? Asking for compensation, my Lord. Now, my Lord, this PMGSY, my Lord, Your Lordship is aware, my Lord, it is the duty upon the state government to make it the land free of cost, my Lord. Then only, my Lord, this scheme is applicable, my Lord. So here's the case, my Lord, the villagers, they want road,
Problem
my
is we
Lord.
can hear, but then
But that I can understand, my Lord.
on the prayer of Mr.
BCBO.
BCBO, Learned Counsel, appearing on behalf of Mr. Tita, Learned Counsel for the petition. Let this matter be listed after 4 weeks. In the meantime, the respondents who have not filed the affidavit may file their responses.
Item number 11.
So many claims. So many.
May I please,
Again,
Lordship,
yes.
Lordship, yes, the respondents yet to file affidavit in the case, my Lord.
What is this? What is this PL about?
My Lord, PL is about the state health department has to be established drug testing laboratory in Arunachal Pradesh. So PAN was allocated by central government in this regard, but there was no any laboratory was established.
This may be genuine one. Then,
my Lord, listen, my Lord, that's why, my Lord, we need some more time, my Lord, because this other is for setting up of the.
who is respondent number 15?
Respondent 15 is a my Lord contractor who took tender for construction of the laboratory testing center, my Lord. So that has not been done, my Lord.
And Ramalan Counsel for the petitioner on the as spread for by Mr. Tita Gumlan standing as the health department as well as you have filed? No. T. Wang Lan State Council as well as Waigao, MS Waigao Land Council appearing for Mr. M. Kantolan DSG. Further 4 weeks time is 3 weeks time is granted to file affidavit, file their respective affidavits. I was service report in respect of respondent number 15. List after 3 weeks.
Much of
Item number 12.
Hmm. 12, 13.
Yes, my Lord.
Yes.
It's 12, my Lord. It is 12 certain similar service report of sort
Private service report. Mr. Tita Gumlan standing on education.
Yes, my Lord.
Department is present. For the appellant is present. Same order. 13 also.
Item number 14.
If I may, my lords.
Yes.
My lords, according to the office noting, my lords, service report in respect of 5 and 6 have returned AD card. 7 and 10 is awaited. And respondent number 11 has filed their opposition, but we have not received it till now, my lord.
Yes, who is 11?
I'm for 11.
Serve the copy. Mr. G. Talolan, counsel for the petitioner. Office note dated 22/07/2026 reflects that services in respect of respondent number 5 and 6 are complete. However, in respect of respondent 7 and 10 are still awaited. List of Mr. So and so. All of them, huh? Land Council, Land Senior Government with for the state, Mr. Opada, Land Special PP, no, Special PP, SCB, as well as so and so are present, huh? List after 3 weeks.
My lord, I had a small prayer if it can be considered, my lord. My lords, there is a little urgency in regarding the my lord, there is a danger of the properties being distracted. The properties we are aware that
What property?
accordingly, actually, my lord, we have made an agreement that compensation has been given against properties which do not exist, my lord. Now, this matter was taken up first in the month of May, my lord. So now 2 months have lapsed.
Who are you?
I'm a resident of that place, the area wherein the land compensation, the road is being constructed, my lord. So, my
Road has been constructed or not?
it is not been, it is supposed to be constructed. The compensation has been given. However, it is our case, my lord, that the compensation has been given to some people who do not have any land there, do not have any properties there. Or in some cases, the compensation has been inflated, my lord. So 2 months have lapsed. So we are praying that, my lord, if possible, my lord, the respondents may be directed to file the reply within 1 week, my lord, because already 2 months have gone by, my lord. Since
Who has filed the
respondent number 11 is the assistant engineer only.
In the meantime, state respondents, as well as the union, respondent union media may file their affidavit. 3 weeks.
Item number 15.
May I please, Your Lordship?
Yes.
This is a jail appeal. Although the jail appeal was filed in the month of April 2026, since there was no application for condonation of delay, so this application is being filed.
Okay. Yes.
It's 2021, the judgment and
delay of?
Sentence. Delay of 1681 days.
Yes, PP.
Yes, yes, Lordship, since this is justiciary appeal, Lordship, jail appeal, Lordship. Lordship, this I have no objection, Lordship.
MS Endangan Leonard. You are amicus?
Amicus.
Amicus Leonard for the applicant as well as Mr. and also Mr. Deloy Leonard, public prosecutor for the state. Next para, this is an application under Section 5 of the Limitation Act 1963. Praying for condonation of delay of 1681 days in filing the connected criminal appeal from jail against the judgment of conviction and order of sentence dated 2011-2021 passed by the Sessions Court, Bombay was saying in Sessions case number 17 of 2012, wherein the appellant has been convicted under section 302/392/34 IPC and sentenced to RI for life with fine of rupees 5,000 under section 302/34, RI for 5 years with fine of 3,000 under section 392 with a default stipulation. Next para, we have is the grounds and the explanation for condonation of delay in filing the connected criminal appeal from jail within prescribed period of limitation. And upon consideration, we are satisfied that the applicant, public appellant, has satisfactorily explained the sufficiently explained the cause of delay. List of according the delay of so and so is hereby condoned. List of then already registered.
Yes. In fact, this jail appeal was filed. Your Lordship had appointed me as amicus. Then it was noticed that there was no prayer for condonation of delay.
It has not been admitted.
I think it was admitted.
Not admitted. Admitted.
I think so because it was under the instructions of this honorable court that this was filed.
Then in criminal appeal, huh? Heard Swencha, amicus curiae, and Swencha admit. Records were called for.
Yes.
Admit and will send.
Reminder for record. Record already.
Admit. Raised to do send reminder for trial court record. List after 3 weeks.
3 weeks. 3 weeks.
3 weeks.
Obliged.
Record is there.
If
In that case,
if records are there, then paper book maybe.
okay. Then in this case, you just records. Trial court record is received. Registered to prepare the paper book. List the matter after on preparation of
Obliged.
paper book. After preparation of the paper book.
Item number 16.
I'm for the petitioner, Your Lordship.
Yes, madam. What is to be done? What is to be done?
On the last occasion, we have taken a steps upon respondent number 4, private respondent.
Even service, you'll have to wait for some. Heard MS?
And Hondik, Your Lordship.
And Hondik Learned Counsel for the applicant as well as MS. K. Wang Learned State Counsel. Await service report in respect of respondent number 4. List after 4 weeks.
Deeply obliged. Lordship, kindly give a fixed date.
Why? Why?
Because here the council is from Delhi base.
Okay.
So he was supposed to appear on
After
the
4
next
weeks.
day.
25 August.
25.
Deeply obliged, Your Lordship.
Item number 19.
Come on.
Yes.
Looks.
Yes, lift it.
Period.
Lordship, it seems
yes, lift it.
DSGI
Period.
is not available today.
No. He is represented by.
Is not available today.
Miss Yao. He is represented by. Yes.
Yes, Lordship. Lordship, the affidavit that the DSGI they have filed, Lordship. They are claiming that the compensation has already been paid, Lordship.
Yes.
But otherwise, Lordship, if we see the affidavit filed by the state, Lordship, there is no record as such being furnished by the state, Lordship.
No, they don't say that the state did not say that the compensation has not been paid. Simply they said records are not available.
So why, Lordship?
So once they say once the requiring authority says that compensation has been paid, nothing remains. Writ appeal dismissed. Okay.
Lordship, There are case laws to show, Lordship, whereby it clearly says that if it is not acquired as per law, Lordship, as per procedure.
It's not a question of acquiring. It's now a question of payment. You have been already paid. Your predecessors in interest have already received the compensation way back in 1975, 76. What remains there?
Lordship, so why,
And
Lordship?
the remaining areas which have not been paid, that has been paid subsequently.
101 or 102.
So why, Lordship, that particular acquisition process that was initiated way back in where they say that the compensation was paid, Lordship, that acquisition process, Lordship, that was not
What
as
acquisition process? Whatever compensation without protest, without objection, your predecessor in interest have already received it.
Lordship, that is disputed, Lordship. We are saying
What
that
disputed? Who will
that-
decide now? It's not disputed.
Lordship, that was paid for crops only, standing crops only, Lordship, not for the land.
No.
And moreover,
Sorry?
Lordship, the acquisition that process that ought to have been processed as per Land Acquisition Act 1894, which was in existence at that point of time, that was not complied with.
You
Lordship.
received the compensation, and after 100 years, you claim that it's not been as per the. How can this be permitted?
Lordship, I have a case.
Anything else?
Similar situated case, Lordship. I have a case law of 2020, Lordship.
Which
Decided
case
by
law?
FX Court, Lordship.
Which case?
DB Basnet versus Collector East District, Gangtok, Sikkim, Lordship. There also, Lordship, compensation was paid, Lordship. But it was that acquisition process was not initiated, Lordship. The state said that the acquisition, the compensation was paid, but the Honorable Court said that since it was not as per the process that ought to have been initiated, Lordship.
Give us the law. Give us the law.
Lordship, 2024 SCC 572, Lordship.
2020. 24.
4 SCC 572, Lordship.
2024.
20, Lordship. 2020.
20.
4
4
SCC.
SCC.
572, Lordship.
572,
Lordship.
Name of the party?
Lordship, DB Besnet versus Collector East District, Gangtok, Sikkim.
Take it out. Let's see.
Lordship, relevant paragraph is 13, 14, 15, and 16, Lordship.
This is the case. Yes, when did you apply? When did you know that this has been under occupation?
Lordship, that Lordship, in fact, since beginning, Lordship, they have sought permission from us to stay for some time, Lordship. Since we had permitted them to stay there, Lordship, on the promise that they will pay compensation in due course of time, Lordship.
No, subsequently there was the certain area has not been paid for
Correct,
a
Lord.
particular area.
Correct, Lordship.
That was paid.
That was
Where you were then?
Lordship, we at that point of time also, Lordship, we have been claiming about the rest of the lane also, Lordship. That they have denied, Lordship, saying that they have already paid. So we approached the authority concerned, Lordship. Now the authority concerned, the Deputy Commissioner clearly has given a letter also, Lordship, whereby it has clearly directed the user agency to pay the compensation as per law, Lordship. That is on record, Lordship.
May I, Lordship? Lordship, it seems from the document submitted by the ITBP, the respondent number, the Union of India, Lordship, page 96, Lordship, the type copy. It appears that acquisition has been made. Yes, Lordship.
Yes. Page
96, Lordship, the typed copy.
96.
Yes, Lordship. May I read, Your Lordship? To the Deputy Commissioner, Siang District along, acquisition of land for SSB, VN and firing range at Basar, Your Lordship. Sir, in continuation to this office letter number, this Your Lordship, dated 31/10/75, I beg to submit herewith attested copies of the following documents regarding payment of compensation of the landowners for the land acquired for establishment of 13 on SSB headquarters and firing range at Basar for favor of your further necessary action, please. Number 1, resolution signed by 9 landowners dated 13/2/76 for payment of compensation for the land required for establishment of 13 in SSB headquarters at Basar, Your Lordship. This is one letter, Your Lordship. Another letter is there, Your Lordship. This page, Your Lordship, it is in page 99. Type copy is at page 100, Your Lordship. To the Commissioner, this is 13 BN SSB Basar, Your Lordship. Payment of compensation for land acquired at Basar and Rigarak for SSB. Your Lordship, it shows that the acquisition was made, Your Lordship.
Page 98.
Yes. Page 98.
With the following landowners hereby agreed to accept compensation at the rate of rupees 5,500 only per acre for land given by so and so.
This is resolution, Your Lordship.
Cease to have any claim right over the present. Yes. 76.
It was, yes, Your Lordship.
Yes.
Payment was made and after the acquisition was made, Your Lordship.
Yes.
Lordship, kindly come to page 148, Lordship. Now the estate cannot blow hot and cold, Lordship. This is the affidavit by the estate, Lordship. Page 148. Paragraph 5, Lordship.
In this, there's no records regarding payment of either for land compensation. There's no record.
There was no record.
The record is with the
yes.
Government of India. I mean the SSB or the ITBP.
It was with the requiring agency, Your Lordship.
Lordship, in the entire process, they say that they have initiated, Lordship. Lordship will see that all those documents were furnished to the administration also, Lordship.
See, page 97, you have signed it, 13/2/17. How many of you are here?
Oh, yeah.
All of them,
How
Lordship.
many of you are here? Page 97.
There six, Your Lordship. There are 6 thumb fingers at thumb prints in the transfer of ownership of land agreement, Your Lordship.
And how many petitioners are there?
9 of them, Lordship.
You are the descendant of or the sons of these 9 persons in page 97.
Correct, Lordship. Yes.
Then, and the case which you have relied, there's no documents to show that the acquisition was done. Here, once you have accepted the payment as per 190 page 97, how can you claim? Have respect for your parents.
Lordship, here, Lordship, those documents which they are trying to project before this honorable court. Now they themselves say that it is not part of their record, Lordship. And that case laws, through that case
Who
laws.
said? Who said? Who said? This is the documents of the ITBP.
Correct, Lordship.
Or the Union of India.
Correct,
And
Lordship.
by affidavit, the state said that there's no record.
So why,
It's
Lordship?
okay. We'll record and writ petition, writ appeal dismissed. Your parents have received it. Have respect for their soul also. Are they alive?
Lordship, some of them have
Are
gone.
they alive?
Lordship, some of them has gone, Lordship. Some of them are alive. Like some of them.
Respect their soul who have gone and have a respect who are still alive. Thank you. Anything else?
Lordship, Lordship may kindly note that the case laws, Lordship, that I have relied upon, Lordship.
I have
That-
noted. We'll record it.
Correct, Lordship. All right.
Okay. Heard Mr. J. Learned counsel for the appellants. And also heard who is 1, who is 2, 3?
I'm for 2 and 5, Your Lordship. 2 to 5.
I'm for 1, 6.
MS Y. Learned counsel appearing on behalf of Mr. M. Kato Learned DSGI for respondent number
1, 6.
and Mr. MS P. Sangita Learned students for respondent number 2 to 6.
2 to 5, Your Lordship.
2 to 5. 1 and 6. You are 1 and 6.
1, 6, 7, 8, and 9.
1, 6, 7, 8, and 9. Pass the order. Writ appeal dismissed.
Obliged.
Pass over matter item number 3.
Item number 3. Yes, you are supposed to file the affidavit.
We are filing it today.
You're filing today. Can it be filed by 1 o'clock?
Yes, Your Lordship.
What is your stand there?
Lordship, we have,
You have taken the steps.
yes, Your Lordship, as per the paragraph submitted to us, Your Lordship, we have got the affidavit of all the police station who are made as a respondent, Your Lordship.
You have taken steps, or you are taking steps to prevent the unauthorized operation or
Some of the police station has, when the FIR was filed before them, Your Lordship, they have sent it to the respective jurisdictional police station where the alleged offense was alleged to be committed, Your Lordship. And in terms of the police station of Kapurnala, Your Lordship, the statement of the complainant as well as the accused were taken, Your Lordship, and it has been disclosed that as per the submission statement made in the FIR that it's a lottery, Your Lordship. The police on investigation found it to be a gift coupon, not a lottery, Your Lordship. and it was not publicly in any manner sold, Your Lordship. And any gift coupon that was given to the was given through the volunteers, Your Lordship. It was not sold.
Is it permissible under the law?
It
Gift coupon and all this are permissible.
coupon as per the Apatani tribe, Your Lordship. It's there is a, if I may read, Your Lordship.
No, some in substance, this police are taking steps to prevent the unauthorized conduct of lottery.
Yes, Your Lordship.
Is not it?
Yes.
That's all. They are taking steps.
No, my lord. Let them bring that on record, my lord. If they say, if I heard correctly, my lord, they are saying this
gift coupons.
This is not.
It's not a lottery.
That's their statement. Let them bring on record, my lord. You can. I'll.
It's also
File reply also.
there was also an allegation, counter allegation, that the petitioner here, he is an interested party, Your Lordship. He himself has conducted a lottery himself when it was not.
He wants to have a unauthorized, operation of lottery.
Yes, by himself.
By monopoly.
Yes, absolutely.
Let them. Yes, my lord. Let them.
You have the documents to show.
Yes, Your Lordship.
Then we'll hear.
Yes, let
we'll
them
impose a heavy cost on you.
Let them bring out record.
When?
Let them
tomorrow. You yourself are organizing a lottery unauthorizedly. Rather, by of this thing, you want to have the monopoly.
No, my
unauthorized.
I'm yet to get the correct allegation of the respondent here also, my lord. Let them bring out then on record, my lord. I will reply appropriately, my lord.
Help learned consent for the petitioner. Although several opportunities have been given to learned additional PP to file the affidavit, same is yet to be filed. Please, however, MS TG learned additional PP submits that she would be filing the affidavit during the course of the day.
Yes.
And we have above, let this matter be listed next week.
Tomorrow.
Tomorrow.
Tomorrow it will be.
Okay. No idea, but
tomorrow
it will not be possible as they have some. I believe they are making some allegation, my lord. I need to reply that also, my lord.
After a week.
After
a week, we'll see. Next week we'll take it up.
Lordship, next week some difficulties, Lordship. Tomorrow, if not tomorrow, then Lordship.
Tomorrow it may not be. Want some time to. Well,
in that case, Lordship, first week of the August, Lordship.
Then we'll say after 2 weeks.
After 2 weeks. All right.
But if we found that, if you find that if you are also organizing, you have also organized unauthorized lottery.
Yes, my lord will see balance of public interest, my lord.
You have to pay.
What public interest here? Say how public injury has been caused.
That I have tried to explain in my petition, my lord. That ultimately, every now and then, my lord, be organized, my lord. Ultimately, this is they are taking money from the public only, my lord.
Whom?
This
who are affected?
Unauthorized lottery, my lord. General public, my lord. I believe general public, my lord.
And who are you?
Yes, my,
you are the one who is organizing.
No, my lord, I humbly believe, my lord, that allegation is yet to come, my lord. Let them.
Whether the public, who are organizing the lottery or the gift coupon, have you implemented them?
No, my lord, we are not.
They are going to be affected. You are seeking for the blanket ban.
No, my lord,
and they are going to be affected.
Ours. My case is simple, my lord. I am not. I am saying, my lord, there is a law, my lord, that need to be implemented by the state, my lord. So I made them a party, my lord, not the five.
Taken a step, register the case, and if they agree by the investigation or the case,
no, my
that's different.
My allegation in PIL is they are not registering the case, my lord. My allegation, my lord.
That is what case that register the case. They have taken.
They are yet to reply that, my lord.
Issue notice or issue notification.
No, my lord.
So they are directing the SP of the
My
company.
lord, see my PIL, my lord. My simple allegation is here is a law bar, my lord, prohibiting us, my lord. Now I have reported to the concerned authority, my lord. They are not taking the action, my lord. This is my simple allegation, my lord. Now, if they are saying, my lord, they have taken, let them file a petition, my lord. I will reply that also, my lord.
No, we'll accept that state that they have initiated an action. At the same time, you
No, my lord, only on simple submission, my
who
lord.
has organized the lottery unauthorizedly in violation of the law.
If you are organizing one, you should implicate yourself also.
My humble son, let them bring all those allegations on record,
Because
my
it
lord.
will affect you also, you as well. You are the one who are organizing, isn't it?
Yes, my lord, if that is so, my lord, that is there. My humble son, let them bring on record, my lord. All those allegations, my lord. I'll file appropriate reply, my lord.
2 weeks.
Obvious, my lord.
For 1 week. Just after 1 week. We'll see.
Obvious, my lord.
Okay. We'll resume after 5 minutes.
trauma सभी जगह जल्दी केस होता होना
Also for matter, item number 18.
Page 10 is the charge. Charge was under 302 IPC. Date is 10/11/22. This is page 10. Along with the charge sheet is the inquest report. This is page 11. Seizure memo. And thereafter, Lordship, the PM report is at page 14. And the sketch map is at page 18. Then your Lordship, the first witness, PW1, is the doctor at page 19. May I read, Lordship? On oath, he says, on 10/7/22, I was posted at PHC Kanewa as medical officer. On that day, one dead body of late Jotin Pafa was brought before by police to PHC Kanewa for conducting PME, and I have physically examined the body and found multiple stab injuries on the chest, abdomen, head of the body, major injury of the body on its head. Longitudinal cut injury over forehead measuring 5 into 8 cm, multiple cut injury on left parietal region, temporal region of the head. I think this should be temporal, measuring about 3 into 2 cm, 2 into 3 cm, and there was stab injury, a stab wound on the right chest measuring ½ inch. There was a stab on the lateral aspect of the left knee measuring ½ inch, superficial cut injury on left neck 8 cm in length, superficial cut injury on left hip 2 cm in length, left cheek bruise measuring 4 into 4 square. On examination, I have found cause of death due to head injury causing subdural hematoma leading to cardiopulmonary arrest. The death of the deceased was homicidal in nature. On completion of PME, I have prepared a report and handed over the same to IO. Exhibit 1 is the PME report, and 1B is the signature of DMO, which I can identify. In cross, he says, it is not possible if the deceased was given medical treatment immediately after injury, he could have been saved. The PO and the PHC Kenawa is situated at a distance of about 35 kilometers. It is a fact that I was not present at PHC Kenewa on 8/7/22 and I went there on 9/7/22. It is a fact that before I reached PHC Kenewa, dead body was brought to PHC for PME. It is a fact that there is no facility for treatment of such. It is a fact that there is no facility for treatment of such injury caused in this case. Then PW2 is a circle officer, page 21. He witnessed the inquest conducted by the IO. May I read, Lordship? Page 21. On oath, he says, on 9/7/22, I was posted at Pipu as circle officer and was in addition charge of Kenewa Circle. On getting information regarding the present case, I arrived at the PO as magistrate with the IO and witnessed the inquest conducted by the IO. When I reached the PO, I have seen the incident took place in an OBT residence. The body was recovered with a blanket. On lifting the blanket, I have witnessed multiple cut injuries over the body. I put my signature in inquest report as witness. Then the inquest report has been exhibited, SP Exhibit 2. In cross by defense, he says, I have received information about the incident approximately at 1 p.m. I reached the PO at 5 p.m. in the evening. I might have put my signature on Exhibit 2 at around 5:30 p.m. Then this PW3 is a neighbor of the accused convict. Page 22. Deepa Pafa. I do not remember the date and year of incident. I came to adduce evidence regarding the murder case which took place at our neighborhood. My residence is just near the residence of the accused and deceased. On the time of incident, it was night. I came out from my residence for attending nature's call, and I have heard unnatural sound of disease. I thought he might be suffering from ailment. Accordingly, after coming back home, I informed about the incident to my brother, Carling Pafa, about the incident of hearing unusual sound from the resident of deceased. He went to the resident of deceased and accused and deceased and discovered deceased already succumbed to injuries. The deceased was killed by his own wife. I did not go to see the dead body. In cross, he says, I have not seen Mekia Pafa killing Jatin Pafa. I have told that the wife has killed the deceased as there was no other person in the residence except the accused and deceased. They were having good relationship. They have 4 children, out of which elder one is a boy and the rest are girl. Lordship will note one thing. She has said that the deceased killed his own wife, but she has not actually seen it. From where this knowledge has come, that is not clear. Then page...
Not wife, husband.
Lordship?
Not wife, husband.
Yes, sorry. Page 23 is the PW for Carling Pafa, the one who was mentioned earlier, is the brother of Deepa Pafa, also the neighbor of the accused convict and the deceased. On oath, he says, on 8/7/22, during the night, I was sleeping at my residence. My sister Deepa Pafa came to my room and woke me up and told that she heard some unnatural sound at the residence where Mekia Pafa and Jotin Pafa reside. After getting up, I went to their residence and seen that Mekia Pafa had already killed Jotin Pafa. I have seen several cut injury over face, neck, and body of the deceased. Bloods were oozing out. I accused Mekia Pafa standing in the dock. Police seized some dao spearhead. I put signature as a witness. He is also a seizure witness, and it has been exhibited as SP Exhibit 3. In the cross, he says, I have not seen the deceased being killed by the accused, I was not read over the content of P Exhibit E when I put my signature. Then PW5 is the wife of Karling Papa, that is the PW4, also a neighbor, page 24. On oath, she says, on the day of the incident, I was sleeping at my residence with my husband, Karling Papa, and my infant child. During the night, my sister-in-law, Deepa, came to our room and shouted my husband. I inquired her as to what happened. She replied that she heard the sound of Aya Aya from the resident of Jatin Pafa. Accordingly, my husband jumped from the bed and rushed to the resident of Jatin Pafa. I also followed him, leaving my sleeping infant. We have seen the door of Jatin Pafa was closed from inside. We have forcefully opened the door and seen accused holding a dao in her hand. She tried to attack us during the time my husband hold her, and I snatched away the dao from her hand and thrown it under the resident. I, along with one of my sister-in-law, has tied Mekia Pafa with a rope, and thereafter I came back to my residence as my infant was sleeping. When I entered the residence of Mekia Pafa, I had seen that she had already killed her husband who was lying. I could not see the injury properly as there was not sufficient light. Light was only near the door for which we are seen her holding the dao when trying to attack upon us, or else she could have killed us. I know the accused standing on the dock, says Mekia Pafa. Then in the cross, she says, I have not seen the deceased being killed by the accused. When I came back to my residence, my husband stayed at the residence of the deceased. He might have seen the deceased properly and seen the injury. I came back as my infant was alone in the residence. Police have recorded my statement. It is not a fact that I have stated before police that the door was open when we entered the residence of the deceased. It is not a fact that I have not disclosed before the police that we have tied the accused. In this lordship, I would like to point out something. This cross-examination, the last 3 lines were done because under 161 statement, she had stated that when they saw, the door was already open. But here she says that they had forcefully opened the door. Then the next page, page 26, is Ayang Pafa, PW6. She is also one of the neighbors. On oath, she says, during the night of incident, I was sleeping at my residence. My sister-in-law, Deepa Pafa, came to our residence and waked me up and told that she heard some unnatural sound at the residence where Mekia Pafa and Jatin Pafa resides. After getting up, I went to the residence and seen that Mekia Pafa had already injured Jatin Pafa. I have seen several cut injury mark on face, neck and body of deceased. Bloods were oozing out. Deceased was about to die, but he was not being able to speak. We have tied the accused, Mekia Pafa, who tried to attack us with a dao. Thereafter, I came back to my residence. I know the accused, Mekia Pafa, standing on the dock. I have not seen the deceased being killed by accused. Sometimes the accused used to behave unnaturally as if she's having some mental illness. We tried to evacuate the deceased to hospital for the medical treatment. But before reaching hospital, he succumbed to his injury. Then, Lordship, the next page, page 27, is the son and the informant of the deceased and the convict. Page 27. Gamma Pafa. On oath, he says, the accused and deceased are my parents. On the day of the incident, I stayed at Sepa. I came to know that my mother has killed my father. She might not have intentionally killed my father. She might have did the same as she was suffering from mental illness. After getting the information, rushed to my residence. I have seen several cut injuries on head, face, and body of deceased. When police came and the inquest was conducted, I was present there and I put my signature on the inquest report as a witness. Police have shown me the weapon of offense, which are dao and spear seized from the PO. Then the P Exhibit 2 inquest report, a seizure memo, and seizure memo of blood, one envelope containing blood sample was exhibited.
He was not at the place of occurrence.
No, he was not there.
Incident, huh?
Yes, he was not there. He was at SEPA, as per his statement. In cross by defense, he says, my parents are farmer. We are 6 siblings. I am the eldest one. The younger sister is about 2 years. There was no quarrel between my parents. We did not have money to take mother for medical treatment. Earlier, my mother attacked my father when she was suffering from mental ailment. Then PW8 is a Gaumbura. He was also he's also one of the witness. May I read, Madam? On oath, he says, I am village headman of Pafa village. On the day of incident, I was at SEPA. I have received phone call from my village that one Jatin Pafa was injured. I rushed with an ambulance to our village. On reaching village, we have seen Jatin Pafa is already died. I have seen the injury marks over the body of Jatin Pafa. I was told by the persons present in our village that the wife of Jatin Pafa, namely Mekia Pafa, has killed him. In defense, he says, police have recorded my statement. It is a fact that the deceased succumbed to his injury at around 8:30 a.m. There was no dispute amongst the deceased, accused and deceased. I do not know any motive for killing the deceased. It may be the reason that accused are suffering from mental ailment when she attacked the deceased. On earlier occasion, also she attacked the husband when she was suffering from ailment. Then PW9 is the IO. Page 29. On oath, he says, accused standing on the dock is Mekia Pafa. On 9/7/22, I was posted at SEPA PS. On 9/7/22, a complaint was received from Sri Gama Pafa, son of late Jatin Pafa at Chagya Camp, Kenewa, that his father Jatin Pafa was killed by his mother Mekia Pafa on 9/7/22 at Chagya Camp. On receipt of complaint, Kenewa PS case number 1 of 22 under section 302 was registered against Mekia Pafa, and I was endorsed the case. On the same day at around 13:15 hours, on receipt of verbal information about the incident, I, along with team of police personnel at SEPA PS and executive magistrate, visited the PO on the same day. On arrival, I have drawn the sketch map of PO and the scene of crime was photographed. I have conducted inquest of a dead body in the presence of executive magistrate and brought the dead body at DH SEPA for PME. Besides three weapon of offense, 2 machetes and 1 spearhead, one weapon of offense was seized from the PO and sent to FSL examination, Gauhati, and report is awaited. Further, alleged Mekia Pafa, who was detained by the relatives and villagers of the deceased, was also taken into custody and brought to SEPA PS. On the next day, PME was conducted at DH SEPA and PME was report was submitted by the MO is enclosed in the charge sheet. The PME reveals that there were multiple severe injuries on various parts of the disease. I have also examined the witnesses and recorded their statements. Accused Mekia Pafa was formally arrested, and during interrogation, she reveals that she killed her husband, Jatin Pafa, on 9/7/22. After conclusion of investigation, it reveals that on the night of 9/7/22, at around 200 hours, one Srimati Deepa Pafa, who was immediate neighbor of the deceased, heard some noises from the house of her neighbor Jatin Pafa and apprised about the same matter to other neighbors, namely Karling Pafa, Fem Pafa, Ayang Pafa. Subsequently, they rushed to the house of Jatin Papa and found that the door of the house of Jatin Papa was open when they entered inside. Inside the house, when they found that Srimati Makia Papa was holding one message in her hand. So this is the statement which is in contradiction to one of the witnesses who said that the door was forcibly open. Holding one message in her hand, whereas Jatin Papa is lying on the floor with several injuries, severe injuries on his body. According to Karling Papa, accused Makia Papa attempted to attack him, but he was narrowly saved by other persons and overpowered accused Makia Papa. At that point of time, Jatin Papa was alive and informed that he was attacked by Makia Papa when he was sleeping. Now, this is a statement which is not supported by any of the prosecution witnesses, which we have read earlier. What they have said is that he had already died. But here, the IO has said that he was informed that Jatin Papa was alive and informed that he was attacked by Makia Papa. Later, Gaumbura Sri Hofio Papa was also reached to the spot after getting information about the incident, and he was also informed by Jatin Papa that he was attacked by his wife. This is also not there in the statement of Hofio Papa. However, as per eyewitness, Sri Jatin Papa succumbed to injuries at around 8:30 hours when they were trying to evacuate him to DH Sepa. On completion of investigation, I found prima facie case under 302 IPC as is well established against accused Makia Papa. Accordingly, I laid charge sheet. The supplementary charge sheet is yet to be filed on receipt of FSL report of the seized exhibits. So the exhibits which were seized, mainly the offense or weapon of offense and the blood samples, they were sent to the FSL according to him, but the report was not there till the time of the trial. So the exhibits he has given is the PME report 1, inquest report 2, seizure memo of offense 3, then seizure memo of envelope containing blood sample 4, the P exhibit 5 is the FIR, P exhibit 6 is a rough sketch map, and P exhibit 7 is a charge sheet. M exhibit 1 is a photograph of the PO, and M exhibit 2 is the photograph of the deceased. Then in the cross, he says, distance between SEPA and PO is 45 to 50 km. It took about 2 hours for me to reach there. On reaching the PO, I have seen the dead body. I have not seen any medical treatment or local treatment provided to deceased. It is a fact that injury was sustained about 2 a.m. The deceased died about 8 a.m., almost 6 hours after the injury. The deceased was alive. I cannot say whether the life of the deceased could have been saved if timely medical treatment was provided. It is not a fact that the PME was not conducted at DH SEPA. During investigation, accused told me that her husband was having extramarital affairs for which she killed him. During investigation, I have not found any such extramarital affair. During investigation, I came to know that in the year 2018, the accused had attacked her husband. I was given information by the relatives of the accused and deceased during investigation. The weapon of offense was seized from the scene of the crime, which is intact. It is a fact that the witness have not seen the accused assaulting the deceased with the seized weapon. Then the accused, the convict has adduced one defense witness, Juni Pafa, which is at page 32. She is the daughter. Their daughter. On oath, she says, late Jatin Papa was my father. Accused standing on the dock is my mother. We are total 6 siblings out of 2 are brothers. Youngest sister is about 2 years. My mother has not killed my father. My mother never had quarrel with my father. There is no past enmity between my parents. I was at Sepa at the time of incident. Before one day of the incident, I was at my village. There was no quarrel between my parents. My mother does not drink alcohol. In cross by PPC says, I know why my mother is accused in the present case. I have not given statement to the police. Whatever I have stated before the court today, I have not stated the same to the police. Then, my lord, page 33 onwards is the 313 examination. It may not be necessary to read this out because everything she has denied. Then page 39 is the sentence order. Page 41 onwards is the judgment. The findings based on this, the points for determination is at page 43. And the findings start at paragraph 22, page 49. Relying on all the evidences which have been provided, the learned trial court has convicted the accused with reasoning at page from paragraph 22 onwards. May I read, Lordship? Page 49 of the paper book.
Is it necessary?
Just to have an idea as to
You tell us
Lordship.
what's your submission. You must have read it already.
Lordship?
You must have already read it.
Yes, Lordship.
Tell us the submission.
Number one, that relying on the PM report, that the death was unnatural, that it was a case of homicide. Then relying on the statements of all the PWs who had seen the dead body, relying on the circumstances, because they found the accused and the deceased together. On that, and also one thing,
and the witnesses has stated that they have seen that she was holding the dog.
Yes. These are said to be circumstantial, and these are said to be one of the main reasons why.
As such, there is no eyewitness as such.
Yes, there is no eyewitness as such. Then there was a claim from the accused that she was
from mental ailment.
Regarding that, Lordship, it may be necessary to read out. Page 54, para 31. There is no medical documents relied on by the parties to show that the accused was suffering from any mental ailment. During the trial of the case, this court has not observed any abnormality in the behavior of the accused person. The accused was arrested on 9/7/22 immediately after commission of the offense, and on the same day she was produced before the doctor for medical examination. I have seen the medical examination report of the 8th SEPA on 9/7/22. It is observed that her vitals were normal and she was fit for keeping in custody, police custody. So basically the court rejected the claim of mental ailment, saying that the medical report on 9/7/22, which usually before arresting the doctor examines an accused person, basing on that, saying that her vitals were normal and that she was fit for keeping in police custody. It is observed that there is no matter to show that the accused was suffering from any kind of mental ailment during the time of commission of offense. Rather, it is found that the accused was very much aware regarding the nature of activities she has committed, for which she tried to attack PW 5 and 6 when they have broke open the door, after which she has inflicted cut injuries upon the deceased. Now, this is very important, Lordship, the last two lines. Important because one of the witnesses, as I have already pointed out,
the door was open.
She has said in her 161 statement that the door was open. The IO has also stated before the court that the door was open. But it is only on her statement, only on that witness statement, who has deviated from her 161 statement to say that the door was broke open. None of the witnesses have stated that, except for this one witness.
So whether this is open or closed,
yes,
he was there holding the door.
No. When they have broken
other than her,
yes,
the appellant, no one is there.
Yes. I agree to that. Rather, it is found that the accused was very much aware regarding the nature of activities she has committed, for which she tried to attack PW 5 and 6 when they have broken open the door, after she inflicted cut injuries upon the disease. So this is a wrong factual
Appreciation.
yes, wrong factual appreciation. I am saying this because if just as an example, if it is a normal person, if I'm caught doing something bad, I will, if somebody opens the door, if somebody breaks open the door, I will certainly try to do something to avoid whatever is coming. If you see it in this context, then it seems like a natural reaction. This is why I'm pointing this out. Whereas the record does not say, in fact, there is a contradiction in the reports saying that the door was open or the door was, the opening or the door being open or the door being forcibly broken open, in my humble submission, changes a lot of things. Because a normal person would not be stabbing another person if the door is open. That is what I'm trying to say. It can be when the door is locked. A normal person would do that. And also, that the attack on the PW 5 and 6 without any reason. If it is a normal person, they may, suppose she's caught in a crime, she may try to kill the witnesses. If the door is locked, if the door is open, it changes everything. I'm trying to veer towards the mental ailment because, Lordship, so Lordship, no mental insanity, insanity, legal insanity and medical insanity are very different things. Legal insanity is the insanity which makes the person incapable of understanding the act itself. It is necessary that insanity should be a medical insanity at that point of time. Unfortunately, in this case, what happened is, even though some witnesses I have read out, some witnesses have stated that she was mentally ill. They have not seen her mentally ill. They are not doctors. Let us remember that. But they know that she used to suffer from mental illness. And they know that the witnesses have also stated, everyone has stated, even the son and daughter have stated there was no quarrel between them. Somebody finally just wakes up and kills a person. The nature of injuries also, Your Lordship will find. Injuries were there almost all over the body. Not just in one place, all over the body. In such a situation, when there is when the witnesses have stated that there is there might have been due to some insanity, the benefit of doubt should have gone to the accused person. I am saying this because the Honorable Supreme Court has said, I'm going to place the citations, the Honorable Supreme Court has said, there are materials, because the act itself, if you want to imagine for a moment, she has killed her husband, for example, the injuries are all over the body. So it means that there must have been a huge fight or something, and then she has attacked everywhere. That means there was no intention as such that she knows what she's doing. In such a case, it is the incumbent upon the investigating officer, because of the situation of the thing also, because one of the witnesses in the 161 statement has stated that the door was open. One person kill somebody with an open door, and when other people come, she randomly attacked them. The act of her, the way the story is projected itself shows that it was not like a normal person. In such a circumstance, it was incumbent upon the investigating agencies to have seen the case from that angle also. That was never done. Number one. Number two, this Honorable Gauhati, the Supreme Court also says that how will the accused plead this case? It is not incumbent on the accused to always bring a defense witness, bring a medical, in this case, to bring a medical document to support the medical insanity. The accused case can be brought by the examination of the prosecution witnesses also. It is not always necessary that it has to be some independent witness. From the prosecution witness itself, it shows that there might have been some insanity. The doubt is already there. And to prove, although the burden of proof of legal insanity is upon the accused, that is only by preponderance of probabilities. It is not as high as the prosecution. My lordship is not agree. I'm going to. That's it.
Unless there is a record.
Yes.
Or has also.
I'll try to satisfy your lordship. So that is my submission. But regarding the other facts of the case, so one thing, I'm time and again going back to the door. The door being open, if it was open.
Who says door was open?
The police.
No, police was not eyewitness. He was not present at the time of.
The only person who says the door was open, the door was broken open. It was closed and the door was broken open. The only witness who said that, so witness who said 61 that the door was open.
161.
Lordship?
Not 161. Before the court also, PW5 you see. We seen the door of so-and-so was closed from inside. We have forcefully opened the door.
This is same witness. This is the same witness.
Yes.
This is the same witness who has stated in 161 that the door was open. This is why I'm pointing out, Lordship. Fem Pafa.
No.
He's the only one who says that the door was forcibly open.
Yes, yes.
In
closed, forcibly open.
This is what she has made a statement here. That is why your lordship will see our cross-examination.
What is the police statement then? Our police statement. She has reiterated the same. Probably.
Lordship. It may be in the record since it is not in the part.
Police, just once. No? Record.
The witness then is Fem Pafa.
She said. I want everybody.
Even if it's she had stated under 161.
Yes.
What does it has any value?
Because they
has stated before the police. And
because she has because that changes everything. Because she has contradicted her own statements under 161.
But it doesn't have that much of value. Would not have any.
61 statements do not have evidentiary value, but they have for the purpose of contradiction. Then Pafa. The seventh line of our statement.
Police statement.
Yes. This is why cross-examination on this point was done.
No, say in her deposition itself, she has said the door was closed.
That is why I'm saying, Lordship. Since she has contradicted her statement under 161, it cannot be relied upon.
Yes, so
that's what I'm trying to say.
Rely on the 161 so to contradict.
No, Lordship. No, I'm not trying to. I'm not saying that what she has stated in 161 should be taken as evidence.
Obviously, you will not.
I'm not saying that. I'm saying that since her statement is totally contradictory to the 161 statement, it cannot be relied upon on this point. Also, the IO has stated before the court that the door was open.
IO.
Page 30, your lordship will see again the IO statement. This will be in the 8th line. 8 line.
Subsequently.
Yeah, subsequently there are, after hearing the sound, according to Dio, after hearing the sound, subsequently they rushed to the house of Jatin Pafa and found that the door of the house of Jatin Pafa was open. When they entered inside the house, they found Srimati Mekia Pafa holding one machete. Now, so PW5 is not only contradicting her statement under 161, she is also, her statement is also in total contradiction with the IO statement before the court.
What house was there? That one,
It is mentioned OBT in one place. Yes.
local house. It's
Oh,
open
it is-
only.
I think so.
Local house generally open only. No,
At night, Lordship, 2 a.m.
no, door open means kept open. Does it mean?
No, this is important because the PW5 says that they broke open. They broke open, Lordship. Broke open means it was closed from outside, inside. That is the meaning of broke open.
Because the local house, it's only sliding. No latch, nothing.
The statement of the PW5 will mention that if it was the case, Lordship.
See the house in the photographs also, it's a local house only.
Yes, Lordship.
Probably there is no system of locking the door. And it's only just.
We have forcibly opened the door. We have forcibly opened the door. This is her statement. We don't know if it is a sliding door. We don't know if it is a openable door. But she has stated we have forcibly opened. We have seen the door of Jatin Pafa was closed from inside. This is her statement. We have forcibly opened the door.
But whatever may be.
Yes.
They have seen once they enter, they have seen that she was holding the door.
Yes. Yes, that I agree, Lordship.
This is one. No.
PW5 is FEM.
Yes.
Okay. Standing inside. Yes, because see that. See that. Yes. Okay. It's only the slide.
Assuming
yes,
if the door was open,
yes,
what does it make a difference?
It makes a difference.
Or are you only trying to, say, contradict this statement of it,
No.
which cannot be relied on?
No, not only on that. That is, of course, one of the reasons.
Ah.
But another reason, what I'm saying is the door being open forcibly, or the door being just open when they reach. It changes a lot of things in the sense that if it was a normal person wouldn't do that.
It
With
would
the
not,
door-
the door would not have been open.
Yes, if the door was not left open, let us use the word left open. If the door was open, normal person wouldn't do that. If it is a normal person, if I have enmity with somebody also, I would do bad things only if the door is locked. I'm inside with that person.
We have no idea.
No, that is that is what a normal person would do. If I attack somebody, if I kill somebody.
We may say the serious hypothesis.
Yeah. Not serious. It is something which is expected of a normal human behavior who is not mentally unsound. That is why I'm saying the door being open or the door being
Taking the same analogy.
Yes.
Suppose if assuming that there's a difference between we can have a distinction of medical insanity and the
legal insanity.
Legal insanity.
Yes.
A person could, after killing
yes
a husband or relative,
yes
could become insanity also.
Maybe.
Is not it?
Yes.
What would be, suppose.
Yes.
If we become sanity.
Yes.
Insanity, sorry.
Yes.
If you don't have a medical, insanity.
Yes.
Right?
Yes.
After killing, after committing the offense of murder, whatever, he or she could become an insanity also. So in that case, could it be a defense of insanity?
No, it would not be.
So why we have to distinguish, differentiate or taking the difference between the legal insanity and the medical?
Legal insanity, as your lordship knows, is when the act is being done at that very moment because of insanity, not knowing the nature of the act. Therefore, unable to think that whatever he or she is doing is wrong. That is the definition of legal insanity.
So the legal insanity,
yes,
if we say so, need not be is as good as a circumstantial thing.
Yes.
Is not it?
Yes.
So for that, you don't have the reverse kind of, burden. You don't have to have a burden to prove that. You have to discharge that burden.
Yes, yes.
That because of these circumstances, because of the legal insanity,
yes,
it has been, the offense has been committed.
The Honorable Gauhati High Court has a division bench in 2018 has said the plea of insanity can be proved by prosecution witnesses also. In this case, your lordship has seen the prosecution witnesses. Although there is no specific statement to that effect, but they feel that the act must have been done due to insanity because earlier there were episodes of insanity also.
Sons and the daughter.
Lordship?
Son and the daughter.
No, other neighbors also. The Gauhati also. May I read again, Lordship?
Maintain ailment.
Yes.
Gauhati said so.
Yes.
Gauhati is
the last witness before
PW8. PW8.
Yes. Page 28. In the cross, he says.
It may be reason that
while asking.
Yes.
Replied, maybe.
It may be seen that
on earlier occasion also, she once attacked the husband when she was suffering from ailment. He said.
In the cross.
Yes.
It was in the leading question.
Then in the PW7, the son, he says in the examination in chief, page 27.
See, we can take
Yes.
reverse view also that on earlier occasion, once she attacked the husband when she was suffering from
Because Lordship,
suffering from ailment.
Yes.
Okay.
The son, Lordship, the position of the son.
Son and daughter, DW1 also said so.
No,
also says that
PW6 also says the neighbor.
the cross. And then she stated before the IO that he attacked because husband was having extramarital affairs.
But none of the prosecution witnesses have stated that. None of the prosecution, not even one.
Who knows?
That is 161
How they
statement
know?
that
How
cannot
they-
be relied on, Lordship.
How would they know?
Yes,
Why
there is of course
It
there.
is only she who revealed.
Yes.
Okay.
PW6 also says, sometimes the accused used to behave unnaturally as if she is having some mental illness. Then PW7, the son, says in on examination or not, she might have did the same as she was suffering from mental illness. She might not have intentionally killed my father. Earlier, then in the cross also she says, earlier my mother attacked my father when she was suffering from mental ailment. Because Lordship,
According to her, can you go through her 161 statement?
Yes.
Which the IO has reiterated probably.
Yes.
It says that she had an argument also, and the husband had the marital affairs, extramarital affairs.
Yes, Lordship, but that was that was not stated by any other witness, Lordship.
In the argument when he denied.
Yes.
Then he assaulted. Out of frustration.
Because the
Clearly stated.
the
This was recorded immediately after the incident.
Lordship,
Mm.
this cannot be, of course, Lordship, ground for conviction. Lordship, what I'm trying to say is, Lordship, imagine the scenario. If the door was open, neighbors say they did not hear anything, any quarrel, except for the sound of aya, aya. Then all the witnesses have stated that the son and daughter also stated that there was no quarrel, there was no problem. Suppose she attacks him. The prosecution witnesses come to the house, led by Carling Paffa. She tries to attack them also. This is what I'm saying, Lordship. I'm saying that the plea of insanity could not have been summarily rejected, taking the help of a medical report which only says the vitals are okay. Medical report which I have pointed out in para 33 of the judgment. The reason why this plea was rejected is based only on that. Medical report which was taken into account is a normal medical report. A person when is being arrested is examined by the doctor. That cannot be an examination on insanity or mental ailment. So I'm taking the surrounding circumstances, not just.
This question probably was never raised. Had it been, then the son, relatives, whosoever may be.
Yes.
Because 6 children.
Yes.
Any one of them must have, could have actually made an application before the trial court.
Yes.
To have her medically examined.
Lordship.
To ascertain the mental illness. That was also not done. No records, nothing. How do we come into conclusion?
Son has stated we had no money for her treatment earlier.
Might be having, she must have, or what? How do we come into that conclusion?
Lordship, if I may state, Lordship, let us not forget that the trial has been conducted by a state defense counsel. The accused persons are poor. The son of the accused person, convict, has stated on record that they were too poor for medical treatment also, for her mental ailment. In these circumstances, all this, we don't know whether such an effective defense could have been provided, Lordship. Although I'm not commenting on the ability of the defense counsel, but
That assumption and presumption how
yes, Lordship.
come into a conclusion
Lordship.
stage.
Yes, Lordship. So, Lordship, I'm aware the prosecution side would say, and probably it's on the mind of the your Lordships also, that the circumstances surrounding the incident, that there was no other person other than the accused person and the convict and the deceased. This thing has to be, Lordship, explained, and that has not been explained. This, I'm sure it will come from the other side. So before that, I'm going
Prior to and immediately after the incident also, she was behaving normally only. And that is what the
a normal person will just a normal person. That is the statement of the IO, Lordship. That is only the statement of the IO. The IO was
no.
IO did not
mental illness.
IO came to know about the incident only the next day. A deceased is supposed to have been attacked at 2 a.m. She was he was supposed to have been attacked at 2 a.m. At 8:30 he's supposed to have expired. IO came to know the next day. From where this statement is coming, we don't know, because the immediate action, because the immediate reaction of the accused person at that point of time, according to the witnesses who had seen her in that state of behavior, according to these witnesses, what she has done is she tried to attack them. This is her behavior. This is not something which a normal person would do.
Her statement immediately thereafter also, it consciously it appears that she has described the situation prior to the incident and then immediately after the incident.
I have period of intermittent insanity, call it, would last. No, that it's because they
said that she didn't remember anything. She didn't say.
Yes.
Her 161 statement.
Yes.
Or just to asserting.
Yes, yes.
She didn't say. She consciously stated the entire situation.
Yes.
How it happened and how thereafter also, because she said that they tried to come in and I tried to protect them, prevent them by showing them. So these are the conscious statement that she was aware.
These are not statements which are proved in the court, Lordship.
That is there, but
yes, these are not. So this may not be taken into account,
because
Lordship.
in order to ascertain if there was any some unnatural, some circumstances or whatever may be the situation, be aware.
Yes,
that is also not there.
In my humble submission, the way
Case you have been given 131, 131,
313 statement, Lordship.
Anything?
Not anything, not explain anything, only just deny. What was that?
Of course, you cannot explain.
Deny.
Now, Lordship, let me come back to my submission. Lordship.
It is not true.
So according to you,
yes,
if not 302.
Yes. In my humble submission, Lordship, number one, even the time of death is not mentioned. Even what type of weapon the injury was might have been caused, that is also not mentioned in the in the post-mortem report. Then, Lordship, this is not even mentioned in the inquest report. The time of death, as per the witnesses, when they entered the house, that time he had already died. Some of the witnesses have stated that. If the statement regarding that the offense occurred at 2 a.m. and the deceased died at 8:30 a.m., if that is correct, then and if the statement that the prosecution witnesses had come immediately after hearing the sound, if that is correct, then these two statements cannot stand, because he had died at 8:30 or around 8 a.m. 8 to 8:30. That is a statement of the IO. But he was attacked at 2 a.m. If he was attacked at 2 a.m., if the neighbors immediately heard the sound, then he could not have died. Then there's some statements. That is also not there, if she was indeed the person who killed him. If when they reached, he died, then they could not have come immediately after his son. It's a huge contradiction there. If he was still alive, because if he died at 8:30 or 8 a.m. and if he was attacked at 2 a.m., if the neighbors come immediately after the attack, then there was ample time for him to give a declaration, maybe give a statement, maybe. There is no such statement. And I'm coming back to the open door again. Since the door was open as per the IO, and as per the 160 was the which was a little contradicted. If that is true, then it cannot be ruled out of some also. How is it possible? According to the police, sent to the officer. I for one cannot. Some would be simply lying down with the other person who playing three weapons of offense, Lordship. That seems unimaginable. It seems even comical. The person should be using three weapons and the person who is just lying down. It's possible. The way he has been attacked, these parts of the body, it is difficult to believe that it would be only the person who has done that. There is a doubt whether the door was open or locked. Somebody also.
She was there. She would be able to tell that.
Now, Lordship,
then she was guarding the dead body.
Lordship is implying section, I don't know the new section, 106 Evidence Act. She is to explain what had happened because she was the only person there as part of the prosecution. In that case also, this honorable court has said case where the husband had killed, the wife. This honorable court has said that in order to come to that presumption also, there has to be some foundational facts. In this case, the weapon of offense was allegedly three weapon of offense submitted. Then the is also not mentioned. What kind of injury was caused by the injury was caused by it's also not mentioned in the PM report. So the foundational facts, if the prosecution has live up to the foundational facts, then 106 evidence also cannot come into it. I'm not required to explain if the prosecution has not discharges burden of the foundational facts. This I'm going to rely on, Lordship.
Continue at 2. Okay. We'll continue at 2 for some time. Judgment now.
Yes, Lordship.
Okay, just give the judgment.
Just 2-3 lines, just to summarize, Lordship. There are various things missing in this case. There are.
There's no link at all.
Yes, the links are broken in various places. Number one, the PM report and the inquest report both do not show any time of death.
PM
report and the inquest report do not show the probable time of death. The time of death is discernible only from the statement of the IO. That is the only thing. Also, the IO has seized 3 weapons, according to him. 3 weapons. And the seizure must have been done much later, because one of the seizure witnesses, there is Gamma Pafa, was not even present in that place at that point of time. The verbal report, according to the IO, was received at 1:15 p.m. in the afternoon of 9 of that day, 9/7/22. 9/7, according to the IO, the offenses must have taken place around 2 a.m. in the morning, 9/7/22. He got verbal information at 1:15 in the afternoon. The FIR was formally lodged at 9 p.m. on that same day, 9/7/22. This Gamma Pafa, who is the PW8, is the son who has lodged the FIR. And he is one of the seizure witnesses. So the seizure must have not, in fact, I would say the proper seizure witness should have been somebody else, but he has also said that he has not been read over the seizure report. Number 3, the way the person has been killed, or by what the person must have been killed, that is not mentioned in the PM report. Your Lordship will see the PM report very closely. It is not mentioned there. So there is a breakage of link between the alleged weapon of offense and the injury cause. Number 3, the injury cause, it seems to be somebody has, whoever has done that, has wielded whatever weapon or whatever thing indiscriminately. It doesn't seem to be a targeted attack. Your Lordship will see the places in which the injuries were there. So therefore,
Offense used in the weapons used in the offense, at least the offense is not been proved.
yes, it has not been proved. It has not even been proved that it could have been, suppose if it is sent to FSL, report does not come. Then also, if the weapon has been seized, the seizure list is there, then also at least the injuries should have connected those the weapon. That is also not there. So it is also not clear as to what time the prosecution witnesses, the neighbors, saw the accused person. Because as per them, he had already died. Now, what time he had died, that is not clear, but according to the IO, he died at around 8:30 a.m. That is almost 6 hours after the alleged attack at 2 a.m. Either they must have found her at 2 a.m. or at 8 a.m. or at 8 a.m. If they had found him at 2 a.m., he was still alive. Why is it that there is no dying declaration proved? If he was already dead, then why was, if he was already dead, then it could not have been 2 a.m. It is also not clear. That is why I'm saying the foundation facts itself has not been proved at all. Before coming to the plea of insanity, then I'm going to cite some, just because of the the manner in which the offense is said to have occurred, it seems so improbable that a normal person would have done it. Because of the door opening, door closing thing also. It is so improbable. And also the witnesses have themselves stated that she used to have mental problems. The son in fact said that they did not have money to go for treatment. Earlier also this kind of thing happened in 2018. Multiple witnesses have stated that. Now, I'd just like to cite some judgments.
That may not be totally correct.
Yes.
Because the witness says that the deceased was about to die when but he was not been able to speak. That is there.
But the IO has stated that he said something.
IO has not seen.
Yes.
Okay.
They also did not take him for medical treatment even after 6 hours. He came only after 9 a.m. This is a division bench of this Honorable High Court.
Citation?
Yes. This is 2018 6 JLR 299. I am relying on paragraph 18 to 21. May I read, Lordship?
Better?
18 to 21. This is on the point that the plea of insanity can be proved by prosecution witnesses. The apex court in Shira I. Wali Muhammad versus State of Maharashtra reported in AR 1972 SC 2443 rejected the plea of insanity of rejecting the plea of insanity observed the law presumes every person to be the age of discretion to be sane unless the contrary is proved. Therefore, the burden of to prove the plea of insanity is obviously with the accused. However, to discharge such burden, it is not necessary for the accused to come to the witness box and to adduce any defense evidence or any formal plea of insanity is necessary. The accused can prove its defense even from the evidence adduced by the prosecution. If from the evidence adduced by the prosecution, it is discernible that the accused was insane at the time of commission of offense, or by reason of such insanity, he was incapable of knowing the consequence of his act. Section 84 of the IPC provides that nothing is an offense which is done by a person who, by reason of unsoundness of mind, is incapable of knowing the nature of the act he is doing is either wrong or contrary to the law. The expression incapable of knowing the nature of the act or that what he is doing is either wrong or contrary to law, appearing in the above provision of Section 84 IPC makes it amply clear that medical and legal insanity are not synonymous. In order to get the protection under Section 84 IPC, it needs to be proved that at the time of the commission of offense, the accused by reason of unsoundness of mind was incapable of knowing the nature of the act or what he was doing was either wrong or contrary to law. Therefore, insanity or unsoundness of mind as contemplated by Section 88 IPC is not at all any kind of insanity. It is such unsoundness of mind which impairs the cognitive faculties of the mind which can form a ground for exception from criminal liability. Section 21, para 21. It is to be borne in mind that in order to prove insanity, it may not be necessary to examine the doctor. In cases, even in the absence of medical evidence, the insanity as contemplated in Section 84 IPC can be established by other evidence, direct or circumstantial, and in such cases, the circumstance and conduct of the accused immediately before, after the occurrence or at the time of occurrence are obviously relevant. The apex court in Dayabai versus State of Gujarat reported in 1964 2CL Criminal Law Journal 472 observed that whether the accused was in such a state of mind as to be entitled to the benefit of Section 84 IPC can be established from the circumstances which preceded or attended and followed the crime. In the present case, neither the doctor nor any other witness was examined by the defense to prove the plea of insanity. The only evidence available on record is a testimony of PW1 who deposed during cross-examination that there was abnormality in the behavior of the accused, but he was not a mad person. PW2 stated that he did not notice any abnormality in the behavior of the accused. In the instant case, admittedly, immediately after the occurrence, the accused went to the police station and surrendered before the authority. This conduct of the accused person following the crime demonstrates that he was not capable or deprived of cognitive facilities of his mind, nor he was incapable of knowing the nature of the act. So this is a case in which the plea of insanity was rejected, but there is an observation that it was rejected mainly because of his behavior after the crime. In the instant case, in the present case now, the act of the accused in attacking the other persons for no reason at all, it doesn't point to a person without any insanity. Now, Lordship, the standard of proof on the proof of for the plea of insanity, Lordship. This is also Lordship reported in the GLT, but it is by the Honorable Supreme Court 2025 case.
So facts
are different, of course.
goes against you.
Yes, Lordship? No, the facts in this case goes against them. In my case, the manner in which followed the crime, alleged crime, is not in conformity with a normal person's behavior.
GLT you have.
Yes. The facts are different in the sense that in that case, what was seen was that the behavior of the accused right after the crime was committed. So therefore, this conclusion was drawn. This lordship is of the Honorable Supreme Court. I am relying on paragraph 5 to 8. May I read, Lordship? Para 5, in the case of Dayabai, Chaganbai Thakkar, a bench of the 3 judges of this court in Para 7 held thus, the doctrine of burden of proof in the context of plea of insanity may be stated in the following propositions. The prosecution must prove beyond reasonable doubt that the accused has committed the offense with the requisite mens rea, and the burden of proving that always rests on the prosecution from the beginning to the end of the trial. There is a rebuttable presumption that the accused was not insane, which when he committed the crime in the sense as laid down by Section 84 of the Indian Penal Code. The accused may rebut it by placing before the court all the relevant evidence, oral or documentary or circumstantial, but the burden of proof upon him is no higher that rests upon a party in a civil proceeding. Even if the accused was not able to establish conclusively that he was insane at the time he committed the offense, the evidence placed before the court by the accused or by the prosecution may raise a reasonable doubt in the mind of the court as regards one or more of the ingredients of the offense, including mens rea of the accused, and in that case, the court would be entitled to acquit the accused on the ground that the general burden of proof resting on the prosecution was not discharged. Then, para 6, the decision has been followed in several decisions, including the decision in the case of Rupesh manager Thapa Supra, wherein this court reiterated that the standard of proof to prove the defense under Section 84 of the IPC is only a reasonable doubt. It is also well settled that a distinction has to be made between legal insanity and medical insanity, and it is not at all necessary to prove medical insanity. Another bench of the 3 honorable judges of this court in the case of Surendra Mishra versus State of Jharkhand, 2011 SCC 495 in para 11 to 13 held thus, in our opinion, an accused who seeks exoneration from the liability of an act under Section 84 of the Indian Penal Code is to prove legal insanity and not medical insanity. Expression unsoundness of mind has not been defined in the Indian Penal Code, and it has been treated as equivalent to insanity. But the term insanity carries different meaning in different contexts and describes varying degrees of mental disorder. Every person who is suffering from mental disease is not ipso facto exempted from criminal liability. The mere fact that the accused is conceited or irascible or his brain is not quite at all right and that the physical and mental elements from which he suffered has rendered his intellect weak and affected his emotions, or indulges in certain unusual acts, or had fits of insanity in short intervals, and that he was subject to epileptic fits, and there was abnormal behavior queer, is not sufficient to attract the application of Section 84 of the Indian Penal Code. The next question which needs consideration is to lies to prove unsoundness of mind. In law, the presumption is that every person is sane to the extent that he knows the natural consequence of his act. The burden of proof in the face of Section 105 of the Evidence Act is on the accused, though the burden is on the accused, but he is not required to prove the same beyond all reasonable doubt, but merely satisfy the preponderance of probabilities.
Only reasonable.
Yes.
Reasonable doubt.
Yes. Then, Lordship, para 7 may be relevant. In case of Bapu alias Gujraj versus State of Rajasthan, 2007-866 in para 8, this court held that thus, under Section 84, a person is exonerated from liability from doing an act on the ground of unsoundness of mind if he, at the time of the doing, of doing the act is either incapable of knowing the nature of the act or that he is doing what is either wrong or contrary to the law. The accused is protected not only when on account of insanity he was incapable of knowing the nature of the act, but also when he did not know either that the act was wrong or was contrary to the law. Then, Lordship, I'll just skip this. Para 8. Therefore, the burden to prove legal insanity is on the accused. It is enough if a reasonable doubt is created about the mental state of the accused at the time of the commission of the offense. The standard of proof to prove legal insanity is only reasonable doubt. Now, Lordship, tying this with the
There is in between the honors of proving unsoundness of mind is on the accused.
Yes, it is on the accused. But how it is to be proven? Through what it is to be proven? That is tied to my earlier citation, Lordship. It is not that medical evidence should necessarily be brought. It is not that defense evidence should necessarily be brought. It can be proved through prosecution witnesses also. Then, my lord, just one last citation. This is I'm, Lordship, not going to read this, or I'll just indicate the paragraphs, Lordship, to save time. This is on the foundational facts, Lordship. This was a case in which almost in the same circumstances, wife and husband alone at home, husband died, and the wife was convicted. Paragraph 14, 50, 51, and 52. Paragraph 14, 50, 51, and 52.
14,
50, 51, and 52. There the learned additional PP had taken the stand that since there were only two persons present, then section 106 of the Evidence Act should be invoked, because the person who was the person alive out of the two had no explanation to give. In that context, the finding is at paragraph 50, 51, and 52. To say that if the prosecution does not prove the foundational facts itself, the question of 106 does not come. It comes only after the prosecution proves the foundational facts. So therefore, in my humble submission, the conviction should be quashed and set aside.
May I please, Your Lordship? If Your Lordship take up section 105 of Evidence Act, Your Lordship. If I may read, Your Lordship. Burden of proving the case of accused comes within exception. When a person is accused of any offense, the burden of proving the existence of circumstances bringing the case within any of the general exception in Indian Penal Code or within any special exception or provision contained in any part of the same code or any law defining the offense is upon him, and the courts shall presume the absence of such circumstances, Your Lordship. Now, Your Lordship will see under 313, neither in the defense nor by the prosecution witnesses as such has proof that the accused herein comes under the exception. Now, if Your Lordship take up the 313 at page number 36, Your Lordship. Page number 36.
Oh, it's not true.
Yes. The specific question with regard to her mental illness was also questioned, Your Lordship, at question number 7, page number 36.
Question number 7, if I may read, Your Lordship. Sri Gama Pafa deposed that the accused and the deceased are his parent. On the day of the incident, he stayed at Sepa. He came to know that you have killed his father. You might have not intentionally killed his father. You might have had the same as you were suffering from mental illness. What do you say? And she completely denies it. It is not true. Meaning thereby that she till the last of her questionnaire under 313 clearly state that she was not mentally ill, and therefore the provision for the exception was never taken into her pleadings, Your Lordship. Now, if I may take Your Lordship to the evidence with regard to the closed door theory, Your Lordship. If I may take Your Lordship to 145 of the Evidence Act, Your Lordship. Now, Your Lordship is well aware that first when the examination starts, it starts with examination in chief. Thereafter, the cross-examination takes place, Your Lordship. 145 is the provision for cross-examination to contradict the statement given under 161, Your Lordship. If I may read, Your Lordship. 145, cross-examination as to previous statement in writing. A witness may be cross-examined as to previous statement made by him in writing or reduced in writing and relevant to matters in question without such writing being shown to him or being proved. But if it is intended to contradict him by the writing, his attention must, before the writing can be proved, be called to those part of it which are to be used for the purpose of contradicting him. Now, if I may then take Your Lordship to the statement of PW5, which Your Lordship will find at page number 24. Page number 24, Your Lordship. Page number 24 is the PW5, who states that we have seen the door of Jatin Papa was closed from inside, which was in the examination in chief, Your Lordship. Page number 25 is the cross-examination by the defense, Your Lordship. Nowhere in the cross-examination has they proof to contradict the statement made in examination in chief, Your Lordship. Now, if that is not proved, Your Lordship, they cannot, the deposition of the witnesses cannot be get away only on this contradiction, Your Lordship. The contradiction has to be proved, Your Lordship. In that regard, I would like to place upon some citation, Your Lordship. Now, Your Lordship is well aware that the IO of the case take the statement under 161, and to contradict any statement made by the witnesses under 161, IO is the only one who can contradict, Your Lordship. If I may take Your Lordship to paragraph 11, Your Lordship, second last page. 11, Your Lordship. 11, second last page it is, Your Lordship. Down below. If I may read, Your Lordship. Before we part with the judgment, we must refer to a peculiar practice followed by the trial court. PW1 and PW3 were confronted in the cross-examination with their statement recorded under section 161 of the CRPC. In deposition, it is mentioned that the attention of the witnesses was invited to a particular portion of the prior statement. After recording the answer of these witnesses, the portion of the prior statement used to contradict the witness has been reproduced in the bracket. Thus, the law is well settled. The portion of the prior statement shown to the witness for contradicting the witness must be proved through the investigation officer. Unless the said portion of the prior statement used for contradiction is duly proved, it cannot be reproduced in the deposition of the witnesses. The correct procedure is that the trial judge should mark the portion of the prior statement used for contradicting the witnesses. The said portion can be used in bracket and marked as AB. The marked portion cannot form a part of the deposition unless the same are proved. Now, when the examination in chief was made, Your Lordship, the defense has full right to prove the contradiction in the examination in chief under 145, Your Lordship. Unless that has not been proved, Your Lordship, the deposition made by the witnesses cannot be discarded, Your Lordship, the portion of the. Now, if I may take Your Lordship to the post-mortem report, which is at page number 14, Your Lordship. Page number 15 shows the injury, Your Lordship.
Page number
15 shows the injury, Your Lordship. And the column, the second last column describe the injury, Your Lordship, and the opinion is given that after this injury, Your Lordship, in my opinion, the most portable cause of death is head injury causing subdural hematoma leading cardiopulmonary arrest. Now, if Your Lordship will see that the doctor could not ascertain as to the time of death, nor by the IO. Why? Because if Your Lordship takes the statement of the IO, Your Lordship, which Your Lordship will find at page number 29. I deeply apologize. The statement of the MO, Your Lordship will find at page number 19. If I may read the
PW1.
PW1, Your Lordship. Okay. Your Lordship will see the page number 20, that is the cross, Your Lordship. It is not possible that if the deceased was given medical treatment immediately after the injury, he could have been saved. The PO and the PHC Kineva is situated at a distance of about 35 kilometers, Your Lordship. 35 kilometers. Yeah, okay. And then the page number 21 is the statement of PW2, who is the magistrate, Your Lordship. If Your Lordships will see the timing, Your Lordship, at the defense part, cross-examination part, Your Lordship, I received the information about the incident approximately at around 1 p.m. and I reached the PO at around 5 p.m. in the evening. Now, when the inquest, this is magistrate who made the inquest report, Your Lordship. Inquest report was made on 9/7/2022, Your Lordship. And he reached in the PO at around 5:55. He made the inquest around 5:30 as per his statement, his deposition, Your Lordship. Now, when the inquest report was made, it was obviously the deceased was already dead, Your Lordship. Now, the timing stated by the IO in his deposition is something that is not on the record as such. Now, with regard to the seizure of the weapon, Your Lordship, I would like to place upon the judgment of the apex court in that term. Your Lordship will first come to the seizure made at page number 12, Your Lordship. The first seizure witness is Gamma Puffer. The second is Curling Puffer, Your Lordship. Your Lordship will then come to the statement of Gamma Papa, which is at page number 27. Who is the son of the deceased, Your Lordship. Your Lordship will, in the cross-examination in chief, the last sentence, Your Lordship. Police has shown me the weapon of offense, which was thou and spearhead seized from the PO, and he has made his signature, Your Lordship. Second is Kama Pafa, which your lordship will find at Carling Papa at page number 23, your lordship. Last sentence of the examination in chief, chief examination in chief, your lordship will find police has seized some dhow spearhead. I put my signature as a witness. So the dhow was seized before these witnesses as a seizure witness, your lordship. The reading over it does not, we are not aware if they were literate or illiterate, but then police has seized some dhow and he has put his signature. He has been witness to that, your lordship. Now, if your lordship may take the citation, your lordship, I would like to rely upon paragraph 7. Paragraph 7, this last page, if I may read, your lordship. The submission on behalf of the accused that as the original informant so-and-so has not been examined and the other independent witnesses have not been examined and the recovery of the weapon was not being proved and there is a serious doubt about the timing and place of the incident. The accused are to be acquitted cannot be accepted, mainly because the original complainant is not examined, cannot be a ground to discard the deposition of PWT. 1. As observed herein above, PW1 is the eyewitness to the occurrence at both the places. Similarly, assuming that the recovery of weapon use is not established or proof also cannot be a ground to acquit the accused when there is a direct evidence of eyewitness. Here, your lordship will see in this case, only the difference was that there was an eyewitness, your lordship. However, in the instance case, your lordship will see the very initial, when the voice was coming from the place of occurrence, your lordship, immediately thereafter, PW3 has informed PW4, PW4, PW5 and PW6 has immediately gone to that house, your lordship.
But then boys, only boys, it cannot be said to be eyewitness.
To the incident, your lordship.
No eyewitness.
Yes, that's why I was saying.
No eyewitness.
That's why I was saying, your lordship. There's the only difference is that there is no eyewitnesses in this in our case, your lordship. In this present case, your lordship. However, your lordship will see since the case is more particularly conviction was made on circumstantial evidence along with other evidences, your lordship. Your lordship will see the circumstances starts from the part when PW3 hears the weird sound coming from the place of occurrence. She informs PW4, 5 and 6 who immediately rush, breaks the door, finds the accused holding the dhow in her hand. She also tried to assault them, your lordship. They have in fact threw the weapon seized the weapon from her hand, threw it, and then called other villagers also and tied her in until the IO came to the place of occurrence, your lordship. There is the Gamburas. If
two of them only.
Your lordship will see the state.
But this the position of PW5, not the whole village.
Yes, they have later on called the Gamburas, your lordship.
But not the whole village.
Your lordship.
The whole village. Only two of them. PW5.
There's a few of them out there. Neighbors.
Okay.
Head Gambura is PW8, your lordship. At page number 28 is the deposition, your lordship. Now, the opportunity was given to her for any explanation under 313, your lordship. She in fact denied her illness, your lordship. Then she also brought DW1 as her defense witness, your lordship, who could not prove neither the illness nor she was also not present at that point of time. So the DW1 in nowhere plays any part to convince the court that the accused was not guilty of the crime, your lordship. And in the midway, your lordship will see there is no breaking of the chain, your lordship. The IO was called. Even the magistrate gave in the deposition has clearly made that since this village was so and so kilometer, she got the information at 1. He arrived at 5:30. Inquest was made, your lordship. There is no breakage of the chain, your lordship. Also, with regard to, I'll just rely. I won't be reading, your lordship.
One more.
This is only with regard to circumstantial evidence and 313. I won't be reading, Your Lordship. I'll just rely paragraphs.
Just give the citation.
Yes, Your Lordship.
313.
I'll give the citations, Your Lordship.
Circumstantial evidence is all already settled.
Yes, 313 also, Your Lordship. Explanation, Your Lordship. And also,
How many judgments?
no, only 2 judgments, Your Lordship. And the earlier judgment is the 3 judgment.
5 judgments.
Yes, Your Lordship. Now, we cannot, while summarizing my argument, Your Lordship, there is no breakage of chain, Your Lordship. Your Lordship.
2 judgments you are relying.
This is 2025 Supreme SC 930.
Why Supreme?
Yes.
Supreme is there is a. It's not reliable.
The corresponding this is 2025 9 SCC 31, Your Lordship. And the paragraphs are
lots of, I mean, reliable in the sense, lots of typographical mistakes.
yes, Your Lordship. Paragraph are 10.15, 10.16.1. These are the 2 paragraphs, Your Lordship, and 10.13. Another is with regard to 106, Your Lordship. It's 2023 Supreme SC 684. The corresponding is, yes, I think, and you like
you have realized.
106 or no? This same is true on the earlier occasion I have placed, Your Lordship. The corresponding is 2023 8 SCC 597, and the paragraphs are 23 and 25, Your Lordship. Lordship, the prosecution has rightly proved, has in every manner proved the circumstances leading to the guilt of the accused, Your Lordship. That is my argument here.
Yes.
Wait, Your Lordship. I will not repeat anything. My learned friend, the additional PPS already shown, the deposit has already been shown twice and judgments have been relied upon. Only one thing regarding the deposit, Lordships has already seen, and from the deliberations that don't know. Don't लिखा है. The only issue remains.
You are a Michael?
Yes.
Okay.
Regarding legal insanity. In fact, from what I have understood, from the learned friend have read out to the 2018 JLR case, that itself would so that the conditions prescribed therein has not been met, except for the fact that earlier, during the incident, thereafter, there is nothing. There is no evidence, except for the fact that what my learned friend was relying upon, that the accused person made an attempt to attack the 3 persons who came in. Then that is just speculation. That may be for various many reasons. So that, my lord, the 2018 judgment does not have. In fact, it goes against the appellant, in my humble understanding. The appellant should have made out a case. The learned friend has already pointed out. Even in the 313, in fact, he has denied. All these statements are only speculative statements by the PWs as well as by in fact, the DW has not even said so. His son said maybe because of that, the Gaumura makes a passing remark, maybe because these are all speculations. So no material has been brought on record to prove legal insanity of the appellant.
What she said is for that the accused need not
That I have understood. That is what I am saying.
the circumstances
Yes.
before and after.
But yes, exactly, I have understood. But there is no evidence on.
As some of the witness has said.
Yes, that is exactly what I am saying.
She had a mental ailment.
Nobody has said she has a mental ailment. There is a speculation. That is what I am submitting.
No, not.
She may have killed him because of mental ailment. That is what they have said. May have. That is the word used. If your lordship wants, then maybe I will take your lordship through that again. Nobody has said conclusively.
Who else are there? PW?
Starts from PW 6 in the defense, or in the cross, sorry. My lord has already pointed out in the cross, it may have been some leading question.
Yeah.
Sometimes the accused used to behave unnaturally as if she is having mental illness. As if she is having mental. What sort of behavior is there for your lordship to come to a conclusion that at that point of time she was suffering from mental insanity? That is my humble submission.
Then
Yes.
PW7?
Yes, PW7 also.
She might have did the same as she
Yes,
was
she might have.
from mental illness.
She might have did the same as she was suffering from mental illness. How does she certify that? Because at that point of time, she did not see it. In any case, this also is a speculative.
No, but by this PW7, he said that she was suffering from mental illness. Therefore,
What mental illness, my lord? What mental illness, my lord?
Of course.
She just says she suffered from mental illness. That is why I was submitting the condition laid down in 2018 JLR, my lord, will not help the appellant. Evidence
this
should have been brought.
Legal insanity or
Yes,
mental illness.
yes.
According
Evidences should have been brought
to her
at least
and
so that these are the instances earlier. She used to do like this. This should have been brought. This was not brought on record. That is what I am submitting.
It need not be proved by the
Yes.
accused. It
That I have
have a reasonable doubt.
Yes, yes.
It has to be proved
Yes.
reasonably
Yes.
and not necessarily by the
Yes, yes, I have understood. What I am submitting is even that is not there.
Okay.
Because if say for the prosecution witnesses, if they have stated before the court that this is the history, she used to do it like this. So even if she that point we have said, so it might have been the reason. So because these are the incidents that happened earlier, except for saying in 2018 or something like that, there are no concrete evidence. I don't want to comment. I don't know. Maybe she should have been defended better or whatever. But the fact remains there is no material before your lordship to come to that conclusion. That is my humble submission.
But the trial court has just relied on the examination of the
To that part, my lord, in my humble submission, your lordships are sitting on appeal.
medical report.
Yes, yes.
That to at the
My
time
lord,
of arrest.
my lord did not look into.
There's no
My lord,
examination as
your lordships did not look into it. Your lordships are sitting on appeal, reappreciating the evidence. Whenever I argue the appeal, I have never read the appeal judgment of the trial court before its honorable court. This is immaterial. The trial court may have come to a conclusion, but the case is now before lordships. Your lordships are
Sir,
representing the
it's
evidence.
a criminal appeal. We can.
No, what I am saying is your lordships are representing the evidence. What the trial court has held in coming to that conclusion of a legal insanity is immaterial.
He has wrongly.
What your lordship has to see now, whether on the basis of
appreciated. See, the accuser arrested on so-and-so. Immediately after the commission offense and on the same day she was produced so-and-so. I have seen the medical examination report, prescription so-and-so. when she was arrested, and it is observed that her vitals are normal, she was fit for keeping in police care. It is observed there is no material show that the accused is suffering from any kind of mental ailment during the time of commission of offense. This is
I have understood that.
medical prescription when the accused was
Absolutely,
arrested.
absolutely. I have understood, my lord. What I am submitting is your lordships are sitting on appeal,
Yes,
reappreciating the evidence.
yes,
So whatever the London trial court may have held,
yes.
that is immaterial. What your lordship has to see now is whether on the material of evidence that the lordships are reappreciating now, whether there is a case of legal insanity or not.
Yes, yes.
That is my humble sir.
Yes, yes. Okay.
That is the humble sir. That part, in fact, I think it's incorrect. My humble opinion. But just because the London trial court has held something, maybe wrongly,
yes,
but that has to be material before lordship to come to a conclusion.
By wrongly appreciating if a person is convicted by on wrong appreciation of the materials or the evidence.
I have understood, my lord. If it was a revision, my lord, I could have understood the query, my lord. But the lordships are sitting on appeal, reappreciating the evidence. Your lordship will now have to.
Yes.
That is my humble.
Okay.
And rest your Justice Sabha has already seen the evidence I have.
Yes.
All three. These are the 3, 4, 5, and 6. They have come on the reporting of the 3, 4, 5, 6 came. Evidence, circumstances to that extent are clear. Everybody has said she was the only one there and she was holding the dog. That is how the circumstances. That's all.
Purely on circumstances.
Yes.
My lord, just 2 lines, my lord.
1, 2, 3.
My lord, I had stated earlier that if the accused was found at the time of the attack, which probably should have been 2 a.m., and if he was alive till 8:30, then why there is no dying declaration? To that, there was a query from my lord, Abu, that the PW, that one of the witnesses said that the accused was about to die at the time when they found. Let us remember that it is the PW 3, 4, 5, and 6 who went to the house at the time. PW 4, I think, alerted everyone and they went to the house. So they went there, according to them, they tied up the accused person. Of all the 4 PWs, that is 3, 4, 5, and 6, it is only PW 6 who says the accused was about to die and then he was unable to speak. PW 5, 3, 4, and 5 has stated that when they arrived, he already died. So it is neither here nor there. Number 1. Number 2, my learned friend has said that the seizure was proper. Even if I agree that the seizure was proper, then also it is meaningless in view of the fact that there is nothing connecting the material seized with the injury in the records. There is not even the slightest thing to be shown that what type of weapon was used, whether it was a dowel, whether it was a blunt weapon, because usually the injury that has been mentioned, subdural hematoma, that is not something that can be usually, so far as I've seen in other medical reports, it is not something that can be caused by a sharp thing. It is usually caused by something blunt. I'm not this case, just for general knowledge. Then, Lordship, one last one. Fem Paffa, in her cross-examination, there was a suggestion from the defense that whether you have stated before the police that the door was open. She has said at page 25, it is not a fact that I have stated before police that the door was open when he entered the residence of the deceased. This she has stated, she was contradicted thus. But so far as the IO is concerned, this question need not even put to him because in cross-examination, in the chief itself, he has said that when they entered the house was, the door was open. So there is even no need of contradicting him. This is his evidence in examination in chief that your lordship will find at page 30 of the IO's deposition. So far as 313 is concerned, 313, your lordship knows, is not a substantive piece of evidence. It is only corroborating the prosecution witnesses. Now, what is there in the prosecution evidence that has proved anything against the accused person? What is there to corroborate there? Even if the accused does not say anything regarding the insanity. So I would like to request your lordships that the case I'm pleading is not only based on the insanity part. It is also on the part that there is not circumstantial evidence at all from what I have already submitted, lordship. To suppose the insanity part is gone, then also there is no circumstantial evidence.
If not,
in both accounts, I'm saying, but
Third person is also possible.
also possible, though. So your lordships may, well,
Second, not of, if not this, then that.
Yes.
We may,
preferably both, but if not that, this. Lordship, oblige,
we may take the middle part.
oblige.
Just one thing. All the witnesses have said that though 3 weapons have been mentioned by the IO, all the witnesses have said they found her holding it down.
Only one.
And your lordship with a page 14, the injuries are all cut marks and steps.
Difficulty is
Step and cut mark.
Yes.
perhaps
Page 14.
the weapon at least to have used in the commission offense has not been linked with either by the expert was saying that they were holding, and there was no official report.
That is the difficulty of the prosecution here.
That is the big gap in the link. Oblige, my lord.
Heard MS and Leonard amicus curiae for the appellant, and also had Mr. Mr. D. Pang Leonard Senior Counsel for appellant amicus curiae for informant or
Victim family.
Victim family.
victim family.
Informant.
As well as informant.
Yes, informant.
Same here.
As well as MS and the TG Land Additional PP for the state hearing concluded judgment reserved.
Okay.
Meet visual lordships.
Yes.
Well, in fact, I had the intention to mention for an unlisted motion, Lord, because tomorrow, right? Deeply obliged.
Lordship, I beg to mention item number 11.
11.
Yes, Your Lordship, there is unfortunately, it is in the last 2 days here, and the matter was listed. I could not procure my file from my chamber. I beg to mention for next week, Your Lordship. And
my lord, I am for the applicant in this matter, my lord. If your lordship kindly sees the earlier
next week
order.
only.
Okay, we'll take it up
kindly,
next week.
Am
Next
I
week.
my lord, am I audible, my lord?
Next week, sir.
Due to
My lord,
fraud
if your
also.
lordship kindly sees the
it is a
earlier
bit-
orders, every time he took time to
On the prayer of Mr. On the prayer of Dr. B.N. Gogoi, learned counsel for the respondent, let this matter be listed after a week. Next para, Mr. SK Ganguly.
Shayok Ganguly, my lord. Shayok Ganguly.
SR Ganguly.
SR Ganguly,
Counsel
my
for. SR Ganguly, yes.
SR Ganguly, my lord.
We'll take. Yes. We'll take it up next week. Yes.
Deeply obliged.
If your lordship kindly fixes a date, that will be grateful, my lord.
Would you like to appear physically?
My lord, I will try to. If your lordship so directs, I will try to appear before your lordship.
When
my
do
lord.
you want? Wednesday?
Lords.
Wednesday, give the date.
March
29?
obliged, my lord.
29, yes.
Deeply obliged.
May I, Your Lordship?
Yes,
So
yes.
I beg to mention item number 10, Your Lordship. Here we need some more time for filing our counter affidavit.
What is the matter about?
Lordship,
Non-payment of salary.
non-payment of
Yes,
3 months.
why? What's
Yeah,
wrong?
for 3 months.
Instruction?
The department is, we need some more time, Your Lordship. Our affidavit is drafted.
No, you just, why he has not been paid the
Saying
salary?
that the petitioner has not joined, Your Lordship.
2 weeks. Heard Mr.
Lordship, there
K.
are
Lowland, London Council for the petitioner. Next, as prayed for by MS P. Pangut London State Council. List this matter after 2 weeks. In the meantime,
praying for
please stop. Considering the method pertains to payment of salary, the respondent authorities shall instead respondent authorities shall file their affidavit. Invariably file their affidavit on or before the next date of listing.
let it be
How would I
fixed.
say
May
that?
Frederick fix that, Lordship.
After 2 weeks.
10 August?
10.
It will be 2 weeks.
Okay. Obliged, Your Lordship.
Yes.
Obliged.
May I, Your Lordship? Your Lordship, I beg to mention item number 12.
12.
Yes, Your Lordship. Your Lordship, this matter may kindly be adjourned for today, as we have not brought our brief, Your Lordship, because our name was not mentioned in the coast list.
Your name is?
Your Lordship, I'm appearing on behalf of the SGIM Kato, Your Lordship. I'm appearing on behalf of the SGIM Kato, Your Lordship, for respondent number 2. Lordship,
You are for petitioner?
Yes, Your Lordship.
No objection?
No.
Any affidavit has been filed?
no, Your Lordship. In the meantime, we will file our affidavit also, Your Lordship.
When do you want?
Your Lordship. I'll be on.
On the prayer of MS?
O Jarang, Your Lordship.
O Jarang London Council appearing on behalf of?
The SGIM Kato.
Huh?
M Kato, Your Lordship.
M. Kato London DSGI and MS P. Sangita London State Council. Let this matter be listed after 2 weeks so as to enable them to file their respective counter affidavits. There's an order. 2, 3 times,
Yes, sir.
2 occasions, 3 occasions. There is a,
DC, we have filed, Your Lordship.
huh?
On behalf of DC, we have filed already.
After that,
Yes.
there's a direction of this court to file on behalf of secretary and director.
Yes.
Huh? This accordingly.
Sir, our name may be
The name of the learned, the Deputy Solicitor General be reflected in the posted.
much obliged.
Item number 1.
Please, Your Lordship.
Yes.
Here the silence is an order of dismissal from service of the petitioner. Lord, so he worked as a bearer in the governor's secretariat, and due to the allegation of overstaying his leave.
Where is this termination?
Termination annexure F page 52.
52. Dismissal or termination?
Dismissal, Lord. Dismissal from service.
52.
52.
Will issue notice. What
Yes.
can we do at this stage? Huh? Madam?
Yes.
Mr.
R. Sharma.
Sharma, counsel for the petitioner. The challenge made in this writ petition is to the order dated 31/05/2024, passed by the secretary.
Secretary to the governor.
Secretary to the governor, Arunachal Pradesh, whereby the service of the petitioner is what?
This
Bearer.
as bearer.
No, the petitioner has been dismissed from service. The petitioner who was working as bearer has been dismissed from service. List of issue notice returnable by 4 weeks. As you are appearing for all.
Yes, Manoj.
MS K. Wang Leonard, state condolences appearance and accepts notice on behalf of all the respondents. No formal notice need be sent. However, extra copies. Sorry, sir.
Item number 2.
Please, my lord.
Yes.
My lord, here the petitioners are putting to challenge the order of the deputy commissioner and the subsequent.
Where it is?
My lord, the order is at page 30, my lord.
30.
30. And my lord, this is related to the land compensation. My lord. Now, that initial land compensation process that was initiated in the year 2010, my lord, that has been denotified, my lord. But what is discernible from this order at page 30, my lord? The Indian Army is willing to, as of now, they are willing to pay for the past occupation charges, my lord. Now, at page 30, if my lord is there, it's hereby informed to all concerned that the Indian Army has decided to undertake the process of regularization of its past occupation of land measuring a total of so and so, and serial number. There are 3 areas, my lord, which has been in, is in the occupation of the army, man. A copy of the relevant map. In this regard, the Indian Army has requested this office to ascertain and identify the genuine land owners of the land under its occupation at the aforementioned locations for the purpose of payment of the past occupation hiring charges. Accordingly, all concerned ZPM, GPCs, GPMs, GVs, and other stakeholders are requested to convene a meeting /Kavang /Gram Sabha as appropriate, involving all concerned and interested parties. The details of the genuine land orders, along with relevant supporting records, documents, if any, may be collected and furnished to this office for further necessary action. Now, by this, some request was made to all the panchayat leaders and the GVs to convene a meeting and collect the records as such of the land owners. My lord,
as such, there is nothing wrong here.
My lord, what I'm saying is, my lord, firstly, my lord, the deputy commissioner, my lord, of course, this is not a process under the land acquisition, my lord. But then the DC is the authority who should, my lord, inquire into these issues, my lord. Now he has delegated his powers, my lord, to individuals, my lord, firstly, my lord. Now, by this order, my lord, that ZPMs and everyone, they have been requested, my lord. Now, sir, interestingly, my lord, next page, my lord, this was the order of the DC is 8th June, my lord. Now, the next page is the one circular issued by the head GV, my lord. Now, taking page 31, next page, my lord, Annexure 5. Now, he derives some power from that order and he appoints himself as the chairman and some members, and in fact, his son also as the member of the committee, my lord. And he proceeds, he issues the circular saying that there will be a meeting as such.
So you are basically against this constitution of committee.
Yes, this and my lord, and the subsequent that finding of this committee as well, my lord. Because what happened, my lord, the DC as such, my lord, DC says you collect the records, my lord, and furnish. Now, what this committee has done, they have went ahead.
So that's why I'm saying, as such, there's nothing wrong in the order of the DC.
Well, DC order, what I'm saying, so because some authority, man, because once you delegate that power to individuals, man.
This is something like it is not exactly under the Acquisition Act.
Yes, my lord.
The army wants to, Indian Army wants to pay the hiring charges.
My lord, that I understand, my lord, but they had written to
Acquisition Act.
They had written to the authorities. At least if the DC had also in fact formed the committee also, there would have been some semblance of transparency and fairness, my lord. Now this Gaupura
This includes everybody, ZPM, GPC, GPM, GBs and other stakeholders.
My lord.
Other stakeholders, everybody.
Yes, my lord.
Every
But
one of them.
my lord, but it is not specific as such. Now this
Are
head
you
chief.
saying that the lands belongs to you?
Yes, my lord.
All the lands?
Yes, my lord. This particularly in this writ petition, my lord, we are with regards to Shivaji Nagar, my lord, where that our claims have been, my lord, rejected.
This is Shivaji Nagar?
Yes, my lord.
Okay.
Now this head Gaupura, he constitutes the committee himself.
Claim has been rejected by whom?
By this committee, my lord, headed by the Gaupura, my lord.
Okay. Okay. We'll issue notice. Huh?
And I have some interim prayer as well.
What interim prayer?
Because this committee doesn't have the authority to decide the title, my lord.
So therefore, what?
So he could not. What I'm praying, my lord, at this stage, my lord, basing on this verification, my lord,
Hmm.
or the minutes of the meeting, my lord, no payment should be made, my lord. Because if there is a dispute, my lord, it has to be decided by a civil court of a jurisdiction, having the jurisdiction, my lord. This committee cannot decide its own. Otherwise, there are various other allegations also. They have submitted the representatives. These persons are interested persons also, my lord. These are other issues, my lord, that we have raised. So it this stage, my lord, that I'm praying, my lord, let there interim. I'm praying for interim also that.
So they have taken a decision,
my lord. That verification report is at, my lord. It starts at page 50, my lord. 50, my lord.
Where your
page
claim,
50 is
your claim has been rejected.
My lord, it is at, my lord, finding is at page 60, my lord.
Okay. And Mr. D. Soki, learned counsel for the petitioners, agreed by the action of the self declared committee headed by one Siri Kagenbu, head GB, Loyang Place, Teju, in the district of Lohit, purportedly in pursuant to the order dated 0806/2026 issued by the Deputy Commissioner Lohit District, Teju, whereby on the request of the Indian Army to ascertain and identify the genuine landowners of the land under its occupation in respect of 11.115 acres of land at Shivaji Nagar, which claims to belongs to the petitioners. All the JPM, GPC, GPMS, GBS, and other stakeholders were requested to convene a meeting and to furnish the details of genuine landowners along with relevant supporting records of legal documents. And also the consequential, the verification.
Verification, my lord.
Where is that verification?
It starts at page 50, man. Page 50 is the forwarding, and then
verification.
It starts at page 52. 50 is the forwarding to the DC, man.
No, what is, and also the minus oblique resolution of the state committee headed by Sri Kogenbu,
yes.
Kogenbu. Is a respondent here?
Yes, he said.
You said wherever I said
Respondent number 3.
Respondent number 3 herein, huh? Comma. The present petition is instituted. List of next para. It is the case of the petitioner that it is the case projected is that the petitioners are the landowners of the land measuring 112.115 acres situated at Shivaji Nagar. Teju?
Yes, my lord.
Teju?
My lord.
Who, on which occupied by the Indian Army without any occupied by the Indian Army. Please stop. The initially land acquisition proceedings was initiated. Our same was denotified. Denotified. Please stop. The Indian Army has requested the Deputy Commissioner to identify, ascertain and identify the genuine landowners of the land of the petitioners, under its occupation for purpose of payment of past occupational hiring charges. List of the Deputy Commissioner on such request has has requested all the concerned ZPM, GPS, same, huh? Page 30. To convene a meeting involving all the concerned and interested parties. Mr. How about the respond number 3 without any authority and in a most illegal manner has constituted a committee consisting of himself and 5 others by involving his relatives only.
Their relatives also and interested parties.
Some of his relatives and interested parties, pursuant to which the petitioner has been deprived of their, has been pursuant to which the claim of the right of the petitioner, the grievance of the petitioner has been rejected without any authority of law. Next para, issue notice returnable by 4 weeks. 3 weeks, we'll make it 3 weeks. 3 weeks. As MS T. Wang Leonard, State Council enters appearance and accepts notice on behalf of
1 and 2, madam.
Respond number 1 and 2. No formal notice need be served. Have extra copies, huh? Petitioners to take steps for service of notice upon respond number 3 by registered pursuant within 2 working days. Next para. Having considered that the Deputy Commissioner by an order dated 08/06/2026, Deputy Commissioner Lohit Singh has directed, has requested all the ZPMs, GPCs, GPMs, GBs and other stakeholders to convene a meeting involving all the concerned and interested parties and to furnish the details of the genuine landowners for payment of first occupation hiring charges by the Indian Army in respect of the land measuring 112.115 acres at Shivaji Nagar, Teju. And also considering that the respondent number 3 privacy appears to have usurped the power without any authority of law, till the next returnable that no payment shall be made. The resolution, the meeting or resolution passed and submitted by the committee headed by respondent number 3 shall not be given effect to. list of, it is clarified that no payment shall be, no payment of first occupational hire charges by the Indian Army shall be dispersed.
My lord. Just my lord, small prayer that resolution date, my lord, that may be 13/6/2026. 2026.
2026.
Deeply.
Have you seen the resolution? The constitution is page 31, committee 31, huh? Then the resolution is page 52. Cover letter is page 50. Just 50.
Problem.
Same.
Same.
In respect
Same
of
in order. Area different.
area is
Yes. I am for Shivaji. I am for Dining Camp and 82 Mount Brigade.
DK.
Yes.
Where it is that order? Where is that order?
Order is at page 30. No, that's
Order of the Deputy Commissioner.
order of the Deputy Commissioner is at page 48.
Page 48. Order of the, this is in the Denning. Denning. Lord Denning. DENNING. Camp. 73.430 acres.
And Lohitpur.
Lohitpur.
Yes.
And the circular same.
Same. Everything same. Everything same.
I mean constitution. Rest resolution. Everything same.
Everything same.
Then
in this case, this is with regard to only 82 Mount Brigade. Here originally I was listed as a land owners, but by these orders I was removed from the list of land owners. So that is the challenge.
So there is a difference.
Different one.
Yes, because initially when in 2011, when list was submitted of the all genuine land owners, my name was there.
So what is the challenge here?
Challenge is the same orders. How my name was deleted now when I was there
Who has deleted?
by the Gauhati committee constituted by
same
the
thing.
Same, everything is same.
So this is in respect of
Denning. This is in respect of 82 Mount Brigade. 82 Mount Brigade.
Not Indian Army. Same
Indian
Army. You add here the illegally deleted by the resolution, name of the petitioner, instead of in reverence, you just write deleted the name of the petitioner.
In other case also name was deleted. The same.
5 also.
5 also.
Name
deleted. From
4 and 5 name deleted.
Name deleted.
Rest same. Grievance of the petitioner in item 2(3). 4 and 5 you just say name of the petitioner deleted by the resolution. Understood? Okay.
Apply.
Yes. Rationalization of the transparent posting.
Yes.
So
Now,
how many teachers at a time?
at the time around 300. But here in this,
See, you obtain instruction. We'll see. We'll take it up Monday, right?
My
Because as per the act and your act itself, transparent posting.
My lord.
Rules.
My lord.
Or the act.
My lord.
Anyone who has the grievance can file a representation.
My lord, is there, my lord. My lord,
so you consider that.
My lord, that part, my lord, I just talked to the department, my lord. In that, what they're saying, my lord, this is, in fact, this is the, even in the prevail in other state also, under the statute, man, it's a statute now. Now they have to make a representation, even if their representation is pending, but it's not the case for that transfer can be suspended or they have to comply. Even if reporting, after reporting the particular place, their case can be considered. It is not a case that they have been released and posted a new place. A posting, their case cannot be considered. Because in certain medical ground also, government has to constitute a medical board. They have to examine if their case is found to be genuine. In that case, they will consider. May not be place where they desire to place, but somewhere where their the condition can be looked into, reconsidered. That the committee is there, Malu.
Okay.
So, but this case, Malu, before they are to comply with this order, Malu, as per statute, Malu, and for that there's a appeal provision also in view of this statute, Malu. Even writ petition is not maintainable at this stage because at page 58, Malu, you see. Page 58 section, it's regarding grievances, redressal, and appeal. There's appeal provision. First, they have to file the appeal before the authority. Grievances have to place before the authority. If the decision of the authority is if aggrieved, then they have to. There's an appeal provision before the CS. Then they can come to the court, my lord.
Yes, sir.
Yes. My condition is that here in the Act itself, it is says that minimum tenure of service is 3 years. Now, 2025, Annexure 2, that is in page 43.
Impugn order is page 22.
Impugn order is in page 22.
Your first or 13th May 23.
22. And my name is appeared in 89 page 43.
Page 26.
Page 26. Now, my grievance is that residential school Kumku. I have been transferred out from residential school Kumku. Whereas my posting place is not at Kumku. I have been transferred out.
Where?
Ketan. I have been transferred out and it will be seen from page 43, Annexure 3. Annexure 2, page 43.
Where is your name in the impugn order?
89.
Page number 26.
26.
Yes, sir.
Yes, serial number. Residential school, Kumku. 2, Gop Middle School, Polosang. Kurungkume.
89.
89.
Kumku, residential school Kumku. It's okay.
Now, my posting place.
Pursuant to Kurungkume.
Yes, and my posting place is not Kumku. My posting place is at Ketan. Ketak.
Okay.
Come to the page 43.
So we'll say that you corrected from Ketan to Polosang. Can be corrected, no issue.
Now, apart from that,
Kumku.
Now,
from Kumku to GPS Ketak. In May, 1 year before.
Yes, the 13th May.
13 years in the present school in own request.
Yes.
Okay.
Now, as per this, that since I have been posted at Ketan, and till completion of 3 years in service,
see,
in the posting place.
Yes, sir. This
I
was,
should be
this
exempted.
was in your own request. And this was before rationalization. Now by this impugn order, it's only one isolated case. 300, how many teachers?
349.
Almost all the teachers by way of rationalization under the statute.
And that is through automatic, Malad. That's portal system. That portal is generate, Malad.
No.
Sir, with the address, we can issue notice, we'll see.
Yeah, other grounds also, no?
Then next ground.
Go to the other grounds. Now, come to the...
Take your seat.
Page 57. Page 57.
Page 57. And chapter 9. Chapter 9.
57,
36.
36. Chapter 9, chapter 11. Chapter 11. The government or the competent authority shall undertake rationalization, deployment, and redeployment of teachers, employee of ensure optional utilization of teaching, non-teaching power. Now come to the two. Compliance with the sanction strength, pupil,
Okay, we'll issue
teacher
notice.
ratio,
And any other ground?
requirement, and in that case,
Page 65 after. Page 65, Your Honor. Page 65.
Page 65.
65.
Yeah.
Yes.
Yes. Yes. Page 65. 12. Rationalization of sanction force against every government school closed aided. Irrespective of RTA by observing the educational scenario of state, minimum 5 teachers shall be provided in GPS and 6 teachers in government upper primary school, including the head of the institute.
Page 81.
Page 81.
This is what? This
is policy, my love. 2025 transfer posting policy. Prior to the statute. Prior to the statute, my love.
At Ketan, we're having only
so the policy may be called teachers transfer and posting 2025.
Yes, my
love. Now
65. Other earlier one is
statute, my lord.
Statute, and it shows it refers to the policy. It refers to the policy.
No, earlier one is what? Which you have
earlier one is
page 43.
Page 57. Rationalization and deployment of teachers employees.
And
this
is under the statute.
This is under the statute. But it's saying sanction should be there. Minimum sanction should be there. Page number 81.
Okay, then
the sanction is given in.
Then we are
81.
81.
Yes.
81 is here. What?
For 4 teachers. Out of 4, 2 have been transferred out.
81 is
number of teachers in the present posting places. GPS data. There are only 4 teachers.
It's okay.
And 2 are being transferred out.
We'll record it.
And as per this rationalization, it should be 5. It should be 5.
Third ground, you know, third ground.
We'll see. We'll issue notice. We'll see. Let them file. We'll see their response.
All the ground.
Then another ground is that is in Schedule 3. Where the transfer can be exempted. That in case of even independent, also, if he is suffer and he need the regular care upon the employee, in that case, his case also be exempted. Now, there is 82.
Page 60. 60, Schedule 3. Page 60.
Now, that is in Schedule 3.
Page
60.
60. Page 60. Schedule
60.
Yes. Exemption from mandatory service obligation.
Page 60. What did it say?
Page 60.
60.
60. Now,
what it is?
This is
exemption from mandatory service obligation. Yes.
Schedule 3.
See,
serious illness or disability of a dependent family member requiring constant care. So here in this case, I have shown the photo of the mother, then whose age is around 90, then 83 is the photo of a father, then he is also around 90, they are bedridden. Then my sister, that is 84, J.T. Palo.
Your sister?
Sister.
Page number 91, page number 91. 91 atla, 91.
91. Yes. 91. Impression. CT picture. Post hemorrhagic chronic disease with encephalomalacia noted in the right temporal and
She's your sister?
parietal lobe.
Yes.
She's your sister?
Yes. Who I'm taking care of.
2021.
It's a continuing disease, Your Honor. 2023, there is also 2023 report also, Your Honor.
It's okay. These are to be considered by your authority only.
Now, and when in the act itself, grievances redressal mechanism has been direct to establish in the state, and it should be heard, and that should not be only a mere formality. See, if I would not submit my representation, referring regarding the grievances, it should be heard. So my contention is that since I have already been submitted my grievances before the competent authority, it should be disposed, and the detailed disposal of my representation, the transfer order may be issued. Now, what I am telling is that page 77. Now, I have submitted my representation.
77.
Representation, and in the representation itself, the DDSC has clearly written that the representation forwarded to the 68. DDSC is 68. 68. DDSC has forwarded it to the Commissioner of Education. Now, here clearly written 1 year, 2 times transfer.
No transfer also.
No transfer. 1 year, 2 times transfer. DDSC has written it. So, then.
Who is above, DDSC or Commissioner?
Commissioner.
Then?
Commissioner.
This is
written by Commissioner only.
Oh.
It was submitted to the Commissioner written only. And this was submitted on 6 July, Your Honor. 6 July till now, they have not come back with any addresses to our representation.
You have already been released.
We have not been released, Your Honor. We have not been released.
No.
Page 77, Your Honor.
Rahul Parna has been transferred from Netaji Subhash Chandra Bose game.
Page 77 is our.
The earlier one, this is.
This is the earlier one. Page 77, Your Honor.
Anyway, I'm not inclined. This rationalization of the transfer and posting of the teachers. It's not the isolated cases. Your case is not isolated. It is consists of around 300?
349.
300. This will be upside down if we interpret. We'll see whether you have the case or not.
They can be disposed of with the direction, Your Honor, for
disposal of our representation.
We'll see. We'll say, we'll provide that pendency shall not be a bar to dispose of your matter. Because you are alleging violation of the statute itself. All right. Heard Mr. Empertin, learned senior counsel.
One case law will submit this one case law.
Not today. Not today. It's a matter of interim order only. Not today.
It concerns the interim.
Next. Learned senior counsel assisted by Mr. Empertin. We'll say we'll record your full name. Mugbam. Mukbang.
Mukbang.
Huh? Mukbang.
Yes.
Mukbang.
Learn counsel for the petitioner. Next para, this writ petition. No, the challenge made in this writ petition is to the order dated 13/06/2026, passed by the commissioner.
Yes,
Commissioner Within bracket Education, Government of Arunachal Pradesh, whereby as many as 349 teachers in the state, including the petitioner, is been transferred and posted in a different in various places of in various schools
of the state of Arunachal Pradesh.
in the state by way of rationalization of the transfer and posting of the teachers under what do you call it? In terms of the
statute, my lord,
where it is
called at page 49, my lord.
In terms of the
Arunachal Pradesh
transfer and posting of employees of Education Department within bracket Regulation and Management bracket close Act 2026, page 49. Huh? The petitioner has been transferred from residential school Kumku, Upper Siang district to government middle school Polosang, Kurungkume district. In the district of Kurungkume, page 26, huh? Serial number 89. Next para. The learned senior counsel for the petitioner submits that learned senior counsel at the very outset contends that the school from where the petitioner is sought to be transferred itself is wrong, as the petitioner was already transferred from the residential school Kumku by an order dated 30/05/2025 to GPS Ketak, page 43, huh? KETAK. List of it submits that the transfer of the petitioner is also against the provisions of section 36
clause 1
clause 36
clause 1
2
2 is for the previous one. 2 is for the previous one where should be done on the basis of
clause 1C.
Clause 1, yes, clause 1C. This is the
clause 1C, page 57. And also the teachers transfer and posting policy 2025, as the petitioners, as the respondent authorities have not considered the teachers students ratio as required to be maintained.
sanction strength
And the
subject requirement
pupil teacher ratio as in the primary GPS Ketak, there are only
4 teachers.
And
now 2 are being transferred.
Out of which two, including the petitioners, has been transferred. Is sought to be transferred. List of. He further submits that as per the provisions of transfer and posting policy of the teachers, the authorities are required to consider the medical problem or what?
Yes, medical dependent.
No, should consider the hardship of the dependent of the particular teacher. List of, by referring to various documents annexed to the writ petition, he submits that the relatives of the teachers, relatives of the petitioner, are suffering from various ailments for which the petitioner is only the who are all dependent on
father and mother, both above,
relatives
and sister.
All relatives dependent on the petitioner. He finally submits that, contends that since the rationalization, the statutes request that the representation of the teachers to be considered, the petitioner, the respondent authorities may be directed to consider and dispose of the representation of the petitioner. Next para. Issue notice returnable by.
Only one part we have already.
3 weeks.
Notice we have already issued. It's already
3 weeks. As Mr. T. Tagum London Education, Eastern on the Education Department enters appearance, accepts notice on behalf of all the respondents.
Yes, my lord.
No formal notice needs be served. However, extra copies be furnished.
Find a written.
3 weeks. Will returnable by 3 weeks.
He said submit file it on to.
Next para. Will not reject your interim prayer, but then will not say anything on that, right? We'll say pendency of the considering that the petitioner has already filed a representation on when?
6 July.
6/07/2026, pendency of the writ petition shall not be, but to dispose of the same, as it appears that it appears that the statute provides for statutes allows the teachers to file a representation for consideration by the concerned authorities. Okay.
Now,
then
another WPC number 337.
Same.
Not same, ground is something different.
Here in a otherwise 6, 7 is same.
Yes, this
6, 7, 8.
The
9 same.
Same.
What is the difference in 337? We'll add that ground.
Here in the case is
he is suffering from some ailments.
No. Will this is a different. He has been appointed as a census duty enumerator.
Census duty enumerator.
You add that
For
in
2000
item 9, right?
Yes, ma'am.
In item 9, the petitioner.
And there's an order.
Before
order is
before press for disposal, that one. Before that, you said the petitioner is that apart. The petitioner has been engaged in the what?
Appointed enumerator census.
Has been appointed
Enumerator for house listing, madam.
House listing of census.
Yes, madam.
And housing census.
Housing census. Housing enumerator for house listing census.
House listing census.
Yes, madam.
House listing census, which requires exemption from transfer.
No. There is an order.
Who's
No,
the exemption
not
from
it.
transfer?
No. Oh,
There's an order.
That's why.
that is why there's a order.
Therefore, this is exempted.
Yes.
Order is there. It should be exempted.
Yes, my lord.
Therefore, that's why I said.
Here my instruction, my lord, here in this case, he was engaged as enumerator for house listing, house census. That part is completed by end of.
File affidavit since we are not making, passing any.
My lord.
This also you have filed the representation.
Yes, we filed a representative.
We're saying, since there's an order that the transparent the person who has been appointed as enumerator or engaged in the census duty shall be exempted from transfer. That's why we said so.
Yeah.
It's only admissible instruction by the subordinate.
okay.
Not,
That's his submission.
My lord. That's.
Okay, thank you. We'll see after 3 weeks.
No, again, there are 2 more.
No,
that has already been covered.
Same, already 7, 8. Any other ground here?
No, my lord, same.
Sir, it's a rationalization of teacher. Let us think about the students. What's happening in India?
One is also only 1 year tenure in his posting place. He was transferred in 2025. In another case also.
Doesn't make any sense.
Yeah.
Okay, that's all.
Yeah, different.